It's a private, well, it's an employee matter.
Right.
So I'd be happy to, I'm John, Director of Communications here. I'd be happy to follow up with you guys afterwards.
John, I'm here with the newspaper, and
Right.
we're here to do a story on this. I heard about it, it sounds like a good story, so that's why we're here.
But it's not a public hearing.
Well, are you saying that you're denying me under the First Amendment, freedom of the press?
No, it's a private, excuse me, it's a confidential employee meeting.
Right, but she would like us to be here. We have her permission.
Well, I'll look into that, but at the moment, you know, it's a private meeting.
Well, the bottom line is, can you show me that in writing? Everything you do has to be in writing. Unless you could show it to me in writing, it doesn't mean anything.
Okay. And who are you with, sir?
I'm with this group.
Okay. Well, I'll get back to you, but at the moment, this is a private meeting.
You're right, but can you show me somewhere in the Constitution where it says you can have a private meeting? And what you're doing, you know the
It's confidential.
You know the Constitution is the supreme law of the land, there's none higher. So what you're doing...
What paper are you with?
I'm with the Walk Hill Journal.
Walk Hill Journal. Very good. Well, and you gentlemen?
We're here also
To
participate and to
Are you with
support
the
her.
Walk Hill Journal?
No, just supporting our friend,
We are Walk Hill Journal.
supporting a friend who can use it, right?
Oh, hi.
Yes, hi.
Silently
Thank you guys
sit
so
by
much
and
for
listen.
coming.
Yes, welcome.
It's so great to have you here.
Yeah, well, we're trying to, I
guys
don't know if we're
come
gonna
in?
get in, I'm
No.
not quite sure.
No, it's from what I understand, it's still a confidential meeting between you and the college. It's not a public hearing.
Well, would you like to have us in there?
Of course I would.
Do you give us your consent?
Yeah, definitely.
So-
Do I have
Her consent.
your consent to
Of
film the
course,
meeting?
Of course, I need some moral support.
So,
Oh, could you
unless you
excuse me?
show me something superior to the
See what he's
Constitution.
doing.
Shoot his ass up.
That's me.
Remember, don't,
Hey, Tony.
Okay, I'll say to all of you outside, pure and simple.
Okay.
and you are,
I'm the hearing officer.
okay?
Oh, I
Hearing
know.
officers in this hearings in this situation are, the only people allowed in the hearing is the respondent and her representative, pure and simple. It's not a public meeting.
We're all her representatives.
No, you're not. Her representative is either an attorney or a union rep. End of conversation.
Constitution says counsel of your choice, doesn't say bar attorney. You got that wrong, sir.
Then you can either leave the hearing or you can represent yourself. That's your choice.
So you're saying you can supersede the Constitution, is that what you're telling me? Get your hands off me.
Excuse me.
How come Mrs. Fiorina is in here, and we've got 1, 2, 3,
Excuse me,
4,
sir.
5, 6 people?
Could you-
who are here?
She gave me her, get your hands off me, please. She gave me her permission to film.
I make the decision.
Okay, and where did you get the authority to make that decision?
Read the law involving section 75.
Section 7, is
And,
that
sir,
superior? Is that all?
please leave.
I have permission from the young lady to be here.
You don't have permission from the hearing officer, please leave. Right
She
now.
gave me her permission to be
Please
here.
leave.
This is my hearing as well. How come I don't have a say?
That's right. Oh, superior.
You've got 1, 2, 3, 4, 6 people to one.
Who are
woman.
you, sir? Identify
My
yourself.
competent
Wait a
counsel.
minute.
No, hold on a second. Are you a lawyer, sir?
Counsel.
Are you a lawyer, sir?
Constitution says you've got the right to
Would you-
counsel of your choice,
Oh,
not
okay.
a bar
Oh,
attorney.
okay.
Does not have
Everybody,
to be
then
a bar
everybody
attorney.
but you will leave the room right now.
No, there's a newspaper reporter
Everybody,
here with
this
me.
is not a public hearing. Everybody
It
but
is.
you will leave the
This
hearing.
building is a public
Sir,
accommodation.
sir.
Sir, don't yell at me, sir. I can yell too. We can have fun today.
Okay, everyone, should we reschedule?
That's what you should do. Maybe you should reschedule. Who's the bar attorney in here?
I am
Is that
the,
you?
sir, I am the hearing officer.
Who's a bar attorney in here? Is
I'm the
there-
college's attorney.
Okay,
I'm
good.
bringing these charges against Ms. Provenzano pursuant to Section 75 of the Civil Service Law.
Okay.
That law does not provide for a private hearing, or rather a public hearing. It provides for the hearing that we're going to go through today, and you should listen to the hearing officer. He is presiding over this hearing. and if he asks you to leave, or anyone else in the room to leave, you or they should leave.
Well, you show me in the Constitution that he has authority over the Constitution to do what he wants. Constitutional law is the highest law of the land, and you people can't make laws against the Constitution. So we are here, she has her rights to be here. Are you familiar with Title 18, Section 242
Sir.
of the Constitution? It says, color of law, deprivation of rights under
Sir,
under
would
color of
you
law
please
can
be
make you
quiet?
liable.
Would you please be quiet and
Go
listen to me?
ahead, speak.
This proceeding was put forth under Section 75 of New York State Civil Service Law. Mr. Banks represents the college. I was appointed as the hearing officer. This is a closed hearing. I make my decision, and the decision may or may not become public. The only people who are here are Mr. Banks, people in official capacities that represent the college. I cannot pronounce your last name, I'm gonna screw it up, so I'm not gonna.
My last name?
Provenzano? Okay. Ms. Provenzano and her counsel. End of conversation. There is nobody else there. Both sides are entitled to call witnesses. The witnesses are sequestered until they are called. Those are the rules of Section 75. Other than that, I will ask everybody else to leave, as I said previously.
Rules do not supersede the Constitution. Anything contrary to Constitution is null and void. This woman is here exercising her constitutional rights, and what you are doing is a violation under Title 18, Section 242 of the Constitution. Anybody that has their rights, deprivation of rights under constitutional law can be held liable.
Can I ask you, what is the harm?
I am not gonna make this hearing.
What do you got to hide?
I don't have anything to
So
hide.
then we should be here.
I said to you before, this hearing, and I've been in public hearings before, and they become a travesty. I am not gonna allow this to become a travesty. This is gonna be a closed hearing, as I've conducted tons of closed hearings before. That's what the hearings process is supposed to be. So I am gonna ask the court reporter and everybody else to leave the room. Right now. End conversation.
The lady gave me her consent to film. This is her film.
This is-
But she can use this for her own private use. This isn't a public film. So
Sir,
she
sir,
gave me her consent.
sir,
I'm staying as long as
I
she
don't
says
care what-
I could stay.
She's not in control. I am in control.
She's in
of-
control of her, and she says she wants
You're in control,
this
you are
film.
in control of
But
me.
by what
Sir.
authority under the Constitution are you in control?
It's-
You're
the
violating her
The
rights.
Constitution is not involved in this case.
Yes, it is. It's the supreme law of the land. And anything
Sir,
contrary to
sir,
it is null and
sir.
void. You just don't know constitutional law. That's the problem. She can be here. She has her rights, and they could be here also. You've got 6 people against one woman,
sir,
and you want her
sir,
to us to
sir,
leave the room, and
sir.
you're gonna be 6-1. That's great odds against a woman. You should be ashamed of yourself.
Sir?
Yes.
So I would like to say, please, this should all remain respectful. I think that we're all trying to hear what you have to say. At this time, we've been informed that this proceeding is not a public proceeding. I agree that Pieta should be allowed to have counsel. I am confused about your role here. You're wearing a press tag, but you said that you're here as her counsel. I don't think that you can occupy both roles at the same time. And just give me 1 second, because you had quite a bit of time to talk.
Go ahead.
When we proceed, please, everyone keep your voices down. And I would really ask, this is a difficult situation for us and for Pieta. And I would really ask that we are able to handle this respectfully and under the rules of the hearing. I'm not an expert, but this gentleman is the hearing officer. I don't think it's necessary to have a confrontation about it.
No, he's
So
making
I'm
a
going to ask
confrontation.
very respectfully for everyone who is not directly involved in being in this meeting at this very moment to please voluntarily leave the room.
We are involved. We're all here on her behalf. We are involved.
That's my request.
And your rules do not supersede the Constitution. That's the problem.
I'm
She
not
has
gonna- I'm
her
not going to-
constitutional
I'm not
rights.
gonna engage with
I know,
that.
because you're not aware of it. That's why I'm here, to educate you.
Steve, should we reschedule that?
I would like to press ahead, because I'm not entirely sure if we reschedule,
Okay.
we're not gonna face a
Then
similar
What
situation.
obligations do we have under the rules of the hearing? Ira, I'm looking at you.
I'm trying to think. I've never been in this situation before in 20 years, in 50 years.
You never had anybody bring up the Constitution before. Supreme law of the
Sir,
land.
sir, enough.
Okay, let's
Enough.
let's figure out the best way forward.
I will allow everybody in this room to sit in the back and keep quiet. Nobody says a word except for Ms. Provenzano. And who is your representative? That's it. Everybody else can sit in the room and one word, everybody is out.
We have no intention to disrupt.
Oh, wait.
Let's proceed.
Okay. He's making an offer. I don't have to accept his offer.
If you want to proceed, you do.
That's another offer. The bottom line is, like I said, we're here to make sure her constitutional rights are not violated.
Can we just have a
Rights in
minute?
this situation.
Can we have a minute just to discuss, so we can resolve this? Is that okay? No.
If you
Just
all
like-
wanna
yeah.
step out.
You're just gonna step out for 1 second. Henry, step out with me in 1 second. This way we can figure out, so, you know, if you wanna proceed and give us the opportunity to sit down and watch.
You want to pass it around?
Yeah, let's do it that way. Yeah, we're gonna do a piece of paper, because I need to put it on the record.
I want everybody to write their name.
You don't have to give your name if you choose not to.
I want everybody, if you don't choose it, if you do not put your name down, you will leave.
Now you're adding a stipulation. You also agreed they
Sir-
get hurt, now you're
sir,
putting a stipulation.
If you do not put your name down, you will leave. End of conversation.
We don't consent to that.
Okay,
Then
we're,
leave.
we're
No, I'm
breaking
not
the
going
hearing.
to leave.
We are gonna you know what, I'm going to consult with the hearing officer, I'm gonna ask if you do not cooperate in the hearing, you do not respect the hearing officer, you do not
The
follow
hearing
his.
officer's not respecting us. It's a two-way street.
He is the hearing officer, he presides, you
He's
have
not
to accept,
God. He's
he
not
has to,
God.
you have to accept his rulings.
No, we
In
don't.
terms of the conduct
If
of the
they
hearing.
violate the Constitution,
Sir,
we do not have to
sir,
accept them.
And I'll put this on the record if I have to.
Oh, okay, hey, let's do this. We're gonna go on the record, we're gonna start on the record, right now. Good morning, everybody. This is a hearing between, this is section, Civil Service Law, Section 75 hearing between Dutchess Community College and Pierina Provenzano. Did I say that right?
Pierino.
My name is Ira Lobel. I was appointed hearing officer by the Dutchess Community College in accordance with the law. At the beginning of the hearing, well, let me, this is the third hearing that's been scheduled. The last two have been postponed due to circumstances requested by Mr. Provenzano, basically illness and that. I got a call at my home this morning, about 8 o'clock this morning, asking for another postponement, and I respectfully said, we can't postpone a third time. That's not fair to everybody, especially given the time of the request. At the beginning of the hearing, the employer was represented by Mr. Steve Banks, an attorney for Thomas Strohan, Waxman, Pettigrew, and Maley, and Miss Susan Rogers, acting VP for instruction, and Mr. Mark Broman, VP for HR. Ms. Provenzano came in with a person who has not yet identified himself and 7 other individuals. This hearing, Section 75 hearing is typically a private hearing. It's no observers are allowed by either side. After significant discussion with parties, including a representative who have still not yet identified himself, I consented to allowing everybody to be here. I asked that everybody sign their name to a document so that they could be identified by the hearing officer, or by the hearing officer and the court reporter. And I further said that if they don't sign their name, they don't identify themselves, I'm gonna ask them to leave. With that comment, I got further pushback by the person who claims to be representing Mr. Provenzano. I'm repeating that request, and I'm emphasizing that request. At this time, I will give both parties an opportunity to say anything, and then we'll begin the hearing. Mr. Banks first.
I do think that this proceeding that we're undertaking or about to undertake is atypical and unusual, and that is typically not the case that you have members of the public or a representative who will not identify himself, who's not a member of the bar, or
I did identify myself. The gentleman that just left here, I identified myself, the director, what was his name?
You did not identify yourself.
He met us out in the hallway and I identified myself to that gentleman, so that's not true.
Okay, well, you have not identified yourself on the record. I would just point out that this hearing was demanded by Ms. Provenzano under the terms of the agreement between Dutchess County and the Civil Service Employees Association Incorporated, or union. And if this hearing proceeds and turns into chaos, if she or a representative don't abide by the rulings of the hearing officer regarding the conduct of this hearing, or her supporters or observers do not abide by the rulings of the hearing officer that pertain to the procedure and process of this hearing, I would ask that she be deemed to have withdrawn her demand for a hearing, and that the charges that have been preferred against her go to the Board of Trustees for approval with a recommendation for termination. So that is our position on the hearing procedure that we're faced with tonight.
Ms. Provenzano, do you want to make a comment?
I don't like the fact that you would presume the withdrawal of the proceeding because I have people here to support me. You're saying, first of all, I know they're not disruptive people. You came in good faith to offer me some support because this is something I've never done, and quite frankly, it is a little intimidating. So, and also, Ira, I apologize for canceling the other 2 times. Unfortunately, I have 2 parents who are ill, one with Alzheimer's, who's bedbound and very sick right now. But with all due respect, you've mentioned your schedule, the inconvenience of your schedule a lot. I've been inconvenienced for the past 14 months because you guys took my job away for nothing. So that's all I have to say.
Okay. Will everybody sign the document and identify yourselves?
They don't have to. You made an agreement they could come in and participate, then you added a stipulation. We don't consent to that. We agreed to your first offer. Now you're trying to make more stipulations.
Please, first of all, would you identify yourself for the record?
I am Henry Harold.
And what is your position?
My position, I'm here as an advisor.
Are you a lawyer? What is your job?
No, I'm not a lawyer. I am here as an advisor. I am not a bar attorney.
Okay. Hi.
Just to clarify, Henry, are you also here as a reporter?
Well, I could be in that capacity, but right now I'm going to take this advisor. I have another reporter right there that can take over everything.
Thank you for clarifying.
Mr. Howe, very simply, the court reporter, in her position as a court reporter, has to identify everybody who's in the in the room. That is part of her duties as a court reporter. very simply, if people don't identify themselves, you know, we made a very quick decision. I could either have people identify themselves on the record, or sign a piece of paper that goes around and she can put it into the record. We decided very quickly that the easier one was the latter.
There's no need for them to identify. They're here only as observers. And
Sir?
you made that, you accepted the
Sir?
offer to be
Sir, very
observers.
simple.
Now you're adding a stipulation.
Very simply, you either abide by the stipulation or we will end the hearing very quickly. I don't want to end the hearing. That's up to you.
If you don't want to end the hearing, then follow what
Sir,
your first
sir,
offer. You
sir,
made a first offer. We
sir,
accepted it.
Sir,
You keep adding stipulations.
I am not adding
You did.
stipulation.
You want names.
Sir,
It's not necessary.
you're wrong.
You're wrong.
And you're not abiding by the rulings of the hearing officer.
Your rules cannot supersede the Constitution. It's the highest law of the land. You could ask for anything you want, but if it's not in line with the Constitution, you can't do it.
Okay, and.
You can try.
You are apparently the supreme arbiter of what is constitutional and what is not. I return to my earlier position. If you refuse to abide by the procedural rulings of the hearing officer, we will break this hearing. And it is the college's position that Ms. Provenzano, by refusing to comply with the procedural rules of the hearing officer, has withdrawn her demand for a hearing under the collective bargaining agreement.
You're putting words in her mouth that she never spoke. And you're making presumptions, and we don't consent to your presumptions.
You don't have to consent to them, we can walk, I can do that.
You can make an offer, but you can't make her do anything.
Why do you need their names?
This is a record, this is a civil proceeding, civil service proceeding for which a record is required. It can be reviewed and will be reviewed by the Board of Trustees. It may ultimately be reviewed by a court of law. You need a clean record. You get appearances from people who are in the hearing room. That is pro forma.
They are only here to observe. They do not have to identify
It
themselves.
does not matter whether the reason they're here. But the minute they are in the room, they have to identify themselves.
Under your rules, but your rules do not supersede the Constitution.
So I think we're talking about the fact that this is meant to be a closed hearing. I think that we've tried to be flexible and allow observers. If the court reporter needs a record of who's in the room, then I don't see how we proceed without a record of who's in the
Well,
room.
if it turns out, because you don't do the right thing today under the Constitution, and there's a federal lawsuit against each and every one of you in your personal and individual capacity, then you'll find out who each and every one of these witnesses are. So that's all up to you. You'll find out then.
Sir, unless we know who they are.
You don't need to know. She's here, she's having a hearing, they're not, they're observing.
Sir, I am not going to repeat it again.
Neither am I.
Either these people sign their names or repeat their names to the court reporter, which is fine. I'll do it orally if you would prefer. Unless they do it, unless I know who everybody in this room is, we are not proceeding with the hearing. End of conversation. Very simply.
They don't have to provide a name under your rules. It's against the Constitution, which is supreme law of the land.
I'm waiting to sign.
And you people can be in violation of Title 18, Section 242 of the United States Code, which is deprivation of rights under color of law. And you could lose your house, your car, your job. You're taking a big gamble, so I wouldn't push if I were you. Just let it go.
Are they signing or not?
I don't know.
Some are signing.
I am.
You don't have to.
It's up to you guys.
I don't mind. I don't mind.
Can't tell you
up
what
to
to
you.
do.
It's called offering consent.
I'm okay with offering my consent.
Okay.
Is it okay? Do you want this filmed?
Sure.
Okay.
I'm not gonna consent.
Then please leave. Sir, then please leave.
He doesn't have to.
Please, sir, please leave.
He doesn't
I am in
have to.
charge of this hearing. Please leave, or I will.
He is under the
Well,
First.
I want you to
the
be
First
quiet.
Amendment.
I want you to be
What
quiet.
want. The First Amendment, freedom of the press. He's here under the Constitution, supreme of the law of the land, freedom of the
and
press.
please
You
lower-
can't stop him from being here.
Henry, please
What?
lower your voice.
Well, he raised his.
I
You
asked
raise
for
it,
it.
I'll raise it.
Henry, here's the answer. Unless this gentleman, one, either has a choice, either leaving or signing the document. If he does not do one or the other, this hearing will not proceed.
You are here under the freedom of the press, under the First Amendment of the Constitution, Bill of
the
Rights.
freedom-
He can't stop that. He has
Sir,
no authority
sir,
over the
Sir,
Constitution.
would you listen to me now?
Go ahead.
This hearing is a closed hearing as set forth in the collective bargaining agreement between CSEA and Dutchess Community College. It is a closed hearing. I made an exception in this case because of your continuing
Because of the
Continue-
Constitution.
continuing concern about the identification of people in this room. I am not going to make a further exception about not knowing who some of these people are. End the conversation.
You made a first offer that they could come
It's
in,
not-
and then you put a stipulation on it in violation of your first offer, and we accepted your offer. Then you went with a stipulation for names, and we didn't accept that.
Fine, then the hearing might be.
Well, then you broke your agreement with
The
us
hearing-
also.
no, it's-
Yeah, you did. You made an agreement
Sir,
that they can
sir,
come in.
Sir,
You keep adding stipulations.
I'm not adding
Yeah, you
stipulation.
did. You want names.
Sir, I am adding a requirement that quite honestly, I did not think about. But the court reporter mentioned, she said, I have to identify the people who are in the room, which sounded to me like a very reasonable commentary.
She could say what she wants as long as it's not in violation of the Constitution.
It is
He's
not-
here
I
under
don't-
freedom of the
sir,
press.
Sir, this is not a freedom of the press issue.
Yeah, yes, it is. The press, that's why they have the First Amendment to the Constitution, for freedom of the press. He can be here.
He can be, I granted, as I said to you, this hearing is a outgrowth of the collective bargaining agreement between Dutchess Community College and CSEA. It is not a question of the Constitution.
Yeah, it is. You're depriving her of her rights. That's the reason she's here. Deprivation of her rights by those charges you brought against her.
If she wants, I didn't bring the charges.
Well, you're presiding over them. I hope you know what you're doing.
Oh, my.
Okay, Henry, whatever your name is, you've been entirely disrespectful, you disrupted this hearing. Here's my position as counsel for
I
the
don't agree
college.
with that. Okay.
Ms. Provenzano, you have a choice. You can proceed, from my position, and I'll leave this to the hearing officer, but I see that you have a choice. You can proceed with today's hearing, abiding by the procedural rules of the hearing officer. That includes having everyone present indicate give it a name, their identification, so it be included in the record. If you choose not to abide by that, and you and your counsel continue to be disruptive, again, I will make an application to the hearing officer that he deem your failure to abide by his procedural rulings, your disruptive behavior, the disruptive behavior of the others present, as a acknowledgement that you withdraw your demand of a hearing.
I don't
This is
agree
your-
my behavior is
I'm not done,
disruptive.
sir.
That's
You
okay.
have an
You're making
opportunity,
assumptions.
Sir,
I don't agree with you making
Sir,
accusations.
sir,
Don't
would you let Mr.
presumption.
Banks finish?
This is your opportunity to respond to the charges. This is your opportunity under Section 75 and the collective bargaining agreement. If you're not, you and your supporters are not going to abide by the rulings of the hearing officer, again, in my view, you are withdrawing your demand, and the charges will stand, and the Board of Trustees will proceed accordingly.
His view cannot
It's not.
supersede the Constitution. They have rules, but their rules cannot supersede the Constitution.
I understand. My position is, these are all my friends and confidants that are here to support me. If they want to give their name, that's up to them. I cannot force anyone to do anything against their will.
And neither can you.
And that does not constitute a withdrawal on my part of this hearing.
Sir.
Piana, then I would like to respectfully ask that, given the constraints and the information that we have from the court reporter, I understand if people don't feel comfortable giving their names, would you be willing to ask them to support you by waiting outside if they don't give their names?
It's their right to be here, they don't have to give anything. This is all rules, and if they are in violation of the Constitution, they don't mean
Can you
anything,
tell
they're
me
null and void.
Why is it you need the names? What?
You should be, in any hearing, one of the things you want to do is identify everybody who's present.
It's not true.
In any hearing, you have to identify people who are present. Regardless of, just in case there are proceedings further. I don't want somebody to be able to say, oh, I was there, and wind up not being there.
They can do it under an affidavit.
It's being
No
billed.
problem.
I cannot write an affidavit.
They can write their own affidavits.
Sir, I'm gonna ask you to let me finish. I cannot do anything if I don't know who's here.
Yes, you can.
Sir, enough said.
They can do their own
Sir,
affidavits.
sir,
If there's a lawsuit, you'll know who they are.
That, I will not know who is here unless they identify themselves. It is vital, it is very important to the process that I know who everybody is. I made an exception in this case to allow people in the room. I'm not gonna allow people in the room who I don't know who they are. End of conversation. You can do what you want. I think it's important for you to abide by the process. And the process is everybody identifies themselves. End of conversation. You want to talk outside with your counsel? You want to talk with me? I don't care.
See, you're either here under your constitutional rights or you're here under their rules, and their rules do not supersede the
I don't know where you're
Constitution.
coming up with the constitutional rights, but that's okay.
Because you don't know the Constitution. That's the problem. Highest law of the land, should know it.
Sir, enough said. Ms. Provenzano, what do you want to do?
Again, I say whoever's is willing to give their name,
But
give it.
what, and then
And
you
whoever
will
doesn't,
do yourself a favor.
that cannot be held against me if they choose not to give their name.
It's not being held against them.
It can't be held against me.
You're right, then you have to simply ask them to leave. I can't allow, and I'll use this as a example. It's not fair for you or for me or for the college to allow somebody off the street to come in and observe this hearing. That's not what the hearing's all about. As far as I know, one of the gentlemen who refused to sign their name could be a person off the street. I cannot, I know you're saying he's not, but then tell me who he is and identify who he is. That's all.
People go into courts every day and sit there and don't
This is not a-
identify
this is
themselves. You
not
don't have to
a court.
identify yourself.
Sir, this is not a court proceeding. This is a proceeding, again, arising out of the collective bargaining agreement between Dutchess Community College and CSEA.
And it has to do with her constitutional rights.
No,
Yes,
it's
it
not.
does.
Okay, I think that
You're
Ira was talking to
depriving her of her
Piana, and I
constitutional
would like
rights.
to hear from Piana.
That's up to you. She's making a request, you don't have to
No,
honor it.
I know, but again, I just, No, I feel that seems a logical response from me. If people want to give information, they give it. If they don't.
Would you speak up about this?
Sure, if they want to give their information, they do. If they don't, they don't.
That is fine, but then they cannot sit in the hearing as because this is not a public proceeding. I am making an exception in this case to allow people who are not directly connected to the proceeding to sit into a proceeding. I will give you an example. This may be a discharge case. That's not open to everybody. That's just not open to everybody. This is a discharge case through Section 75. It's not open to, the rules throughout the country. That's not a public proceeding. I'm making an exception in your case because of what's going on for the last 45 minutes to allow this to be a quasi-public proceeding. But part of the reason the only way it's going to be a quasi-public proceeding is if I know who the people are in this proceeding. The press are not normally allowed in a discharge case. End of conversation. That's been the rules.
Not true.
That's been the rules in labor law for the last 100 years.
And it's in violation of the First Amendment of the
Sir.
Constitution, freedom of the press.
You-
You've been making a mistake all the time, but nobody
Sir,
took nobody took you to task.
Sir, it's been challenged, and it's been challenged against what you're saying. Pure and simple. It's been challenged dramatically against what you're saying.
Well, it hasn't gone to federal court, then it'll be
It-
taken up. That's where
Sir.
federal rights are hurt.
Sir, you are mistaken.
Well, you'll see. Read Title 18, Section 242, we'll see who's mistaken. What they're trying to do is get you to waive your constitutional rights and go under their rules, and then you chop liver. That's what they want you to do. You have no rights. If you waive your rights, you have no rights.
She's not waiving her rights.
Yeah, that's what you're trying to do.
We're not waiving any rights.
This has to do with her constitutional
Sir.
rights, which you're doing to her today. You want to fire her for certain reasons.
I would like to hear from both her and the college as to what the reasons are for firing her. I don't know that. I don't know anything about this case right now. You're trying to deny her the opportunity for me to find out what this case is all about.
Why don't you know about anything in this case? How could you come in here and preside and have no knowledge? Maybe you
Ms.
need to take an
Ms.
adjournment and find
Provenzano.
out.
Ms. Provenzano, I told you what I require to have this case proceed today, or in the future, because this is your chance. It's pure and simple. The people who are in the room who are observing this case with you, for you, they have to identify who they are. Pure and simple.
Not true. He's not telling you the truth.
Mr. LaBelle, we have been at this for some time. I've not heard Ms. Provenzano say that she's going to abide by your procedural rulings. Her alleged counsel has been disruptive throughout this entire process.
I don't agree with that statement.
At this point, I would move to end the hearing and for her demand for a hearing under Section 75 and the agreement between Dutchess County and the CSDA be deemed to have been withdrawn because she's been provided a opportunity for a hearing, but is failing to abide by your procedural rulings, failing to abide by the process that this hearing entails. She and her counsel have been entirely disruptive.
I
So
don't
at this
agree with
time,
that.
I would move that we end the hearing and that I ask for a ruling that her demand for hearing be deemed to have been either abandoned or withdrawn based upon her disruptive behavior and that of her support.
We don't consent to your allegation of the disruptive behavior. She is exercising her constitutional rights, and you people are trying to get her to waive them. A rule does not supersede the Constitution. Marbury versus Madison.
Interesting case.
Yeah.
Ms. Provenzano, Mr. Banks has made a motion. I would prefer not to rule on that motion. I would prefer to proceed with the merits of this case. If you don't like some of the rules I've done, you can challenge those in an appeal. But right now, I am very seriously considering accepting his motion and moving on. I don't want to do that for your sake.
You can object to his motion that he's violating your constitutional rights. He can motion all he wants. You can object to him.
You're right. She can object to it. And if I rule the way Mr. Banks has suggested that I rule, which I'm very, very seriously considering doing, her appeal process is limited to procedure. And she will never, except maybe 5 years from now, get a hearing on the merits. I want you to get a hearing on the merits. That's what you came here for, I think.
As long as it conforms to your constitutional rights and it doesn't violate them. And anything he makes a rule on, you don't have to consent to it, and you could sue him in federal court under Title 18, Section 242. And now a federal judge will decide to it, and they can all be liable in their official and personal capacity. You can own their houses.
Pardon me, Henry, one moment. I think her friends wanted to speak to you outside for a few minutes.
Okay.
Anthony, could you join them, please?
Excuse me.
I think they wanted to speak to you as well.
Okay, yeah, I'm gonna,
I sent you all a document today,
Thank you.
about documents I'm going to sign.
I have, shortly after you called me this morning, I got in the shower and drove in the car, so I haven't seen anything. So,
Do you have a laptop?
I'm gonna say it orally, as it was written. I can give it orally, as you said.
pardon?
I can give it orally, as you said.
What's your position as
Okay, then everybody's gonna give it orally.
All right, and then we can get spellings and, okay.
See, that's, bluntly, that's why I wanted to give it.
She'll have to spell it out, but-
I have to spell it out so
That's
she
fine.
can read it.
Spell out.
Okay,
So unfortunately, like I said, I sent you the document, I sent to you, and then I sent it to the president.
to the,
To the president.
okay. Well, hold on, let's go.
Yeah, are we getting?
Let's go back on the record.
So are we getting people's names?
Everybody is signing the document. I want to make sure that everybody can read the writing. You said you don't want to sign it?
I'll do it orally.
Okay, could you do it orally, sir?
Yeah, Anthony DeLulo, D as in David, I, capital L, U, L, L, O.
I apologize. I can't make out that.
Me?
Is that you?
No, this is me. You want me to say it?
No, that one I got.
Okay.
Do you know who that is?
No.
Is that you,
No.
sir? Is that you? Oh, you did it again. Thank you.
And before
Oh,
we continue,
thank you.
I would please like to have everybody's name. And what's your name, ma'am?
Dr. Susan Rogers.
Susan Rogers.
R-O-G-E-R-S.
Okay, and you, sir? Mark. Bowman, B-O-W-M-A-N. And you, sir?
Stephen Banks, B-A-N-K-S.
Henry, what's your last name?
And what's your name, sir?
Henry Harold, family of Williams.
Henry?
Harold, family of Williams.
Still can't hear.
Mark, are you a bar attorney? I'm Steve. I'm sorry, Stephen, are you a bar attorney?
Yes.
I still don't know.
Henry, would you please spell your last name?
Williams. The last part of who I am.
Henry Williams.
Henry Harold, the family of Williams.
Okay. Okay,
And your name, sir, again.
Ira, IRA,
Oh, that's right.
Lobel, Lobel.
Okay. And you, ma'am?
I'm Catherine with a C,
Catherine?
correct. Kunkel, Kunkel, court reporter.
Kunkel.
Right,
Court reporter?
yes.
Court reporter. And you, ma'am, what's your name?
Nilda, Nilda,
Uh-huh.
Nilda, Nilda, last name is Hoffman, Hofmann, and I'm the Chief of Campus Safety Security.
Okay.
That's my offer of settlement. Did everyone else sign?
And you, sir?
John
Yes.
Nagel, Meagle.
Meagle?
Yes.
Okay.
Ira, can we get the pad back?
What's the title, John?
Director of Marketing and
Ira, can we get the
Communications.
pad back?
Pardon?
The pad.
So there's two things.
Yeah, he's got
Oh,
it.
okay,
We got everything?
oh, okay.
Don't let me forget to.
I will. Is it okay with you if I write your name?
Sure. Do you remember?
I have it written down.
Okay.
Catherine
Thanks.
Kunkel.
Yes.
Okay, let's proceed.
Okay.
And we want to continue with this as long as you do not violate her constitutional rights and it's within constitutional law.
Mr. Williams.
And what Stephen Banks said before, he wanted to make a motion, is that we object to that motion that he made before.
Now that we have gotten all the signatures and all the identification of everybody in the room, we're gonna proceed with this, we're gonna proceed in the normal course of events, in the normal course, I hope. Very simply, Mr. Banks makes an opening statement. Ms. Provenzano can, or her counsel, can make an opening statement, and then we proceed with witnesses, first by Mr. Banks, then by Ms. Provenzano. I normally ask the question at the beginning of any hearing, is there a reason for the two counsel to step out in the hall and see if we can resolve this thing? I am guessing that that's not even worth asking in this particular case.
It can be, it's up to him.
I would object to doing that.
Okay?
Okay, let it be the record, I agreed to do it and he objected.
It's on the record.
Great.
Okay. Mr. Banks, opening comment.
Mr. Lavelle, good morning. We're here today under Section 75 of the Civil Service Law and the agreement between Dutchess County and CSA to consider charges brought against Ms. Provenzano. Just as a housekeeping matter, I do have the college's exhibits and binders. I'm providing one binder to Ms. Provenzano. I have another binder for you. Exhibit A of the binder is the resolution of the Dutchess Community College Board of Trustees dated July 13th, 2022, authorizing disciplinary charges against Ms. Provenzano and also appointing you as a hearing officer to preside over the Section 75 hearing. And I would move that Exhibit A into evidence.
Any objection?
I object
On what basis is it? It's
to Section 75. I don't believe it applies to me. Section 75 speaks of misconduct and incompetency. The definition of misconduct is improper behavior, especially neglect of duties. Incompetency is lacking qualities knowledge, skill, ability to do something. I don't think that applies to me. Also, I would like to say that the college has had me on unauthorized leave for 14 months. And the definition of unauthorized leave is failure to report to duty without permission. Section 75 speaks of suspension. There is no mention in Section 75 of unauthorized leave. The truth is, I was not on unauthorized leave. I was suspended. If unauthorized leave means failure to report to duty without permission, I reported to duty. And I was directed to leave on 3 separate occasions. So I reported to duty to work. That is not unauthorized leave.
Oh, okay. That is an argument that you will make when you present your case.
Okay.
Okay? Right now, all I want to do is get through the documents.
Sure.
You know, Exhibit A is an official document. Made by, proffered by the college. I understand why you do not agree with it, but it's still an official document, so I'm gonna let it in over your objection, but understand that it's an official document. You're disagreeing with the nature of how the document was written, okay? I understand that.
I have another question. What is the format here?
He's gonna make his presentation,
And then I make mine.
then you make yours, and hopefully we can get through all the exhibits without too much disagreement.
Okay.
And he calls his witnesses, you call your witnesses, and then we're done. Okay?
Would I be able to call a witness from my department?
Yeah.
Okay.
Okay, continue.
So, again, I have Exhibit A, I offer that into evidence.
It's admitted.
So then, Exhibit B are the charges of misconduct in a letter dated July 19, 2022 to Ms. Provenzano. There are 5 specifications. The college will withdraw specification number 1 and proceed on specifications 2 through 5. This is a fairly simple case. Ms. Provenzano has a job with the college. She has not been at that job for more than 14 months. She's last been at her job last October of 2021. Since then, she has failed to report to work. She has failed to comply with directives to return to work. And when the college had COVID-related requirements, such as masking, she refused to comply with those requirements. And therefore, she was not fit to work while she refused to comply with COVID-related protocols. The college has reached out numerous times, including in December of 2021 and in March of 2022, directing her for return to work, and certainly in March of 2022, informing her that even there had been a change in COVID-related protocols and that masking was no longer required. Nonetheless, she has refused to return to work, and she has not been at work since October of 2021. Based on her insubordination, based upon her refusal to work, based on essentially job abandonment, all of which are acts of misconduct, the college is seeking her dismissal from service.
Okay. Opening statement?
This whole thing has come to be because I refused to mask and test. So because I chose not to vaccinate, I had to mask or test. And you can let it be known for the record that I am not here to defend myself. I stand by my decisions. You cannot make someone employment contingent upon their personal medical decisions. I had a job description. I was never informed that you adjusted my employment contract. Here, I have my job description. It doesn't say anything about masking or testing or waiving my rights. No such provisions were ever given, so I'll not be held to that. I showed up for work, ready and able, and prior to these mandates, I was never considered insubordinate. There was never any misconduct. So I deny the charges are valid at its inception. I have a constitutional right to make decisions involving my body, my well-being, my bodily autonomy. And no one under the Constitution can deprive me of that or hold my job over my head as a result. And this is a quote-unquote disciplinary hearing. I've committed no crime. I need to be disciplined for nothing. I have done nothing wrong. So what I'm telling you is what the college has done to me is harassment, coercion, and unconstitutional. Like Henry has been saying, rules, mandates are not laws. And that's what we're all held to. So all of your emails, I counted with my sister. I was harassed and coerced to try and mask and test. I was told to do that at least 20 times. So I'm not here to deny that. I'm here to show you why you need to settle and remedy the damage that you've done. And you have done damage. I have been unemployed for 14 months. You have me on unauthorized leave, which is a lie. And as a result, I've not been able to collect. And it never should have taken this long. That's it.
Okay.
I also have a big presentation here. I don't know if you want me to start. I have a lot of case sites.
We have a lot of,
Case sites too.
well, the case sites normally go in your brief. They're normally not part of the proceeding at this time. I'm not sure what they are. That's,
Excuse me? A lot of times in court, when they make decisions, they base a lot of decisions on case sites, which is what attorneys like to use. And she has all these case sites to support what she's stating here today. Now, she can leave a copy with you for you to read, and I strongly suggest you should, or you
I
can
have
ignore
done-
them, but
I have
they're
done my
still
due
here.
diligence.
okay.
And they're in her favor.
Let me go back a second, and then I'll discuss the case notes. I often do it before the opening briefs, or opening statements. I'm gonna do it right now at the opening statements. In any Section 75 proceeding, the issue that I must decide is, very simply, was the employee properly disciplined pursuant to Section 75 of the Civil Service Law? Pure and simple, very simple. If not, what is the appropriate penalty, if any? Do you agree with that?
Yes.
Do you agree with that? That's what I have to decide. I know you're just saying that obviously you don't believe that you were properly disciplined. I understand that. Okay. What happens is in a proceeding like this, he calls various witnesses, you call various witnesses. At the end of the hearing, you either make closing arguments or you submit briefs. 99% of the time, parties submit briefs. In those briefs, the parties include whatever legal documentation they want. Okay? I'm just telling you how the proceeding.
Now, I'm trying to understand it, because I wasn't aware that I had to submit.
Okay.
I just thought I had to
No, okay, I
do my
understand.
homework and present my side.
Okay, I'm trying to teach you as well as, okay? And one of the things that also happens is the briefs are obviously shared with the other side. Every once in a while, and it's been very rare and all the time I've been an arbitrator, the opposing party says, we want to write a reply brief. You know, just so you know what you're, that takes extra time before you can make a decision. Okay, I just wanted to explain to you what the process is. Having said that, having included opening statements, do you want to call your first witness?
Yes.
Well, wait a minute, one thing, just my interjection. I understand you make your decision, and what we're just stating is that your decision under the Constitution, which is the highest law of the land, must be made and not violate her constitutional rights. So I'm giving you a caveat, keep that in mind.
Sir, I make my decision based on the contract in Section 75 of the Civil Service Law. Pure and simple.
As long as it's in line with the Constitution.
Sir, you have an appeal process. Everybody does. Call your first witness, please.
The college will call Mark Bowman as a first witness. We also intend to call Dr. Rogers as a witness, and I would ask that she step out during Mr. Bowman's testimony.
Sure. Why is that?
It's called sequestering witnesses. It's commonly done to prevent her from conforming her testimony or from a witness conforming his or her testimony with another witness.
Okay. Makes sense.
Mr. Bowman, would you raise your right hand? Do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes.
Hold on for one second. I was gonna say, he looks young enough, that he, don't put this under review. Every once in a while, you see a kid being called to testify. Which is my right hand? I saw you almost do that for a second. Just teasing you. I want to keep it a little bit light. Okay, go on, Mr.
Mr. Bowman, good morning. My name is Steve Banks. I'm attorney representing Dutchess Community College. Where are you currently employed?
Dutchess Community College,
And what position do you hold?
Associate Vice President of Human Resources.
And generally, what are your duties as Associate Vice President for Human Resources?
Manage all functions regarding human resources for the Dutchess Community College.
And when did you assume this position?
January 2, 2022.
Do you know who your predecessor was in that role?
Bruce Spencer.
As the Associate Vice President of Human Resources, are you the custodian of personnel records for employees at Dutchess Community College?
Yes, I am.
As Associate Vice President of Human Resources, are you the custodian of records of the Office of Human Resources Management at Dutchess Community College?
I am as well.
Do you know Ms. Provenzano?
Personally, no, I do not. I have not met her.
Do you know what position she's held at the college?
Yes.
And what position is that?
Program assistant.
It's actually senior office assistant.
Now, in front of you, there are a binder with some exhibits. I'd like to direct your attention to Exhibit C. And that identification can be found in the lower right-hand corner. What is this document?
This is a written reprimand for insubordination and job abandonment to Ms. Piran and Provenzano.
And who sent this letter?
Bruce Spencer sent this letter.
Is this a document maintained by the Office of Human Resources Management at Dutchess Community College?
Yes, it is.
Was this document created in the regular course of business of the Office of Human Resources Management at Dutchess Community College?
Yes, it is.
Is Exhibit C a true and accurate copy of the letter sent to Ms. Provenzano on December 14th of 2021?
Yes, it's true and accurate.
I'd offer at this time Exhibit C in evidence.
Any objection? And just for the record, B is also in evidence. I assume you don't have any objection to that either.
On C, it looks like you superimposed something on what was here and kind of redacted it, because there was something over this, I could see below it, and it looks like, was something
What was the
placed
date of
above
that?
that?
What was the date?
December 14th.
2021?
Correct.
So it looks like something was placed above the body of this. There was something underneath this, and this was placed on here to cover something else up. What was that?
Ms.
Mr. Bowman?
Provenzano, to your knowledge, is this a true and accurate copy of
I'm
it?
looking for mine.
Okay.
'Cause this was altered.
I have it right here.
Let's see.
Are we okay?
Well, we reserve comment for a later date.
So this
Go
is,
ahead.
And she has it right in front of her.
exhibit. Was this the first exhibit or the second one?
This is Exhibit C.
This is Exhibit C.
Okay, can you just remind me of the others?
A was the board resolution authorizing charges and appointment of hearing officer. Exhibit B,
1 second. You'll give me copies of this?
there's a binder right for
Oh,
you.
thank you.
Yeah. In fact, you have two now.
Did you read Exhibit C, Peter?
Yes, I have.
Is there anything in
I'm
here
familiar with this.
that you don't agree with?
Okay.
Because if you do approve, that means you agree with it.
No, as I said to you before, all this is the documents that she received. She has a right to challenge the documents, but this is just an indication, is this the document you received?
It is the document I received.
Okay. So I'm admitting it to evidence.
Yeah, and
Oh,
only
wait.
yes to that.
Or is he done saying what he had to say about this document?
You'll do the, if you want to challenge it, you can challenge it on cross.
Okay.
Okay?
We could ask Mr. Bowman question.
Go on.
Mr. Bowman, I wanted to direct your attention at the bottom of the first page of this letter. It states, on October 18th, you returned to work but refused to wear a mask or be tested. That is why you were asked to leave, which you did. Do you know if Ms. Provenzano has returned to work after that date, October 18th, 2021?
No, she did not.
Wait, I'm sorry. Can you repeat that? I apologize. What was the question?
Did you return to work after October 18th?
Yes, I did.
Again, that's what you're gonna be,
Okay.
that's what course
Got it.
examination.
I'm learning, thank you.
Okay. As far as Mr. Bowman says, you have not returned to work.
And I would just note, I'll continue. Now, Mr. Bowman, I want to direct your attention to Exhibit D in the same binder. This is a two-page document, and I first want to start with the second page. What is the second page of Exhibit D?
It is a letter regarding job abandonment.
And to whom was this letter sent?
Pierre Provenzano.
And who sent it?
I sent it.
And what's the date of this letter?
March 18, 2022.
Is this a document maintained by the Office of Human Resources Management at Dutchess Community College?
Yes, it is.
Was this document created in the regular course of business of the Office of Human Resources Management at Dutchess Community College?
Yes, it was.
Is the second page of Exhibit D a true and accurate copy of the letter you sent to Ms. Provenzano on March 18th, 2022?
Yes, it is.
And what is the first page of the same exhibit?
First page is a letter regarding the job abandonment.
And to whom is it sent?
Pierre Provenzano.
And who sent it?
I sent the letter.
And what's the date of this letter?
The letter is March 18th. I'm sorry, April 20th.
Was this document created in the regular course of business of the Office of Human Resources Management at Dutchess Community College?
Yes, it was.
Is the first page of Exhibit D a true and accurate copy of the letter you sent Ms. Provenzano on April 20th, 2020?
It is correct.
At this time, I'd offer Exhibit D in evidence.
Any objection?
In this letter, it states that I was notified in a letter dated December 14, that I must return to work, and I was not.
Okay, again, you can challenge the accuracy of the letter on cross
In other
examination.
words, you're just asking me if I object to this being entered.
Is this the letter you got?
Yes, it is.
Okay. Go on.
Is admitted?
It's admitted.
Okay. Mr. Bowman, just going back to the second page, the March 18th letter, what was your purpose in writing this letter?
It was to inform Ms. Provenzano of her rights and regarding job abandonment.
And the letter is sent to an address in Wappinger Falls at 120 Channingville Road. Was this an address that your office had on file for Ms. Provenzano?
Yes, it was.
Did you subsequently learn of a different address for Ms. Provenzano?
Yes, we did.
And if you refer to the first page of Exhibit D, is that the address that she provided to you?
It is the one Ms. Provenzano provided.
And at what time, do you know, did she provide your office with that address?
Before April 20th, 2022.
Was it after March 18th of 2022?
Yes.
In your letter dated March 18th and resent on April 20th, did you give Ms. Provenzano a directive regarding her reporting to work?
Yes, we did.
And what directive did you give?
It was to return to work.
And by what date?
It was to return to work by March 28, 2022. That was, she did not report by that date.
Did she report to work by March 28, 2022?
No, she did not.
Did she report to work after you resent the letter on April 20th, 2022?
No, she did not return to work.
In the second to last paragraph of the March 18th letter, did you describe any requirements relating to COVID for employees of Dutchess Community College?
Yes, we did.
And what did you inform Ms. Provenzano in this letter?
It was regarding the wearing mask status or wearing not mask status.
Okay, and what was the requirement at the time of this letter for employees regarding wearing of masks?
The indication was not to wear a mask, but you would have to participate in weekly testing.
At the time of the March 18, 2022 letter, were Dutchess Community College employees required to prove their vaccination status?
Yes.
Your letter states otherwise.
It was you would have to participate in weekly testing if you did not want to if you did not have a vaccination status.
So if she had returned to work by March 28, 2022, she would have to undergo weekly testing.
Correct.
Okay, so, I'd like
No.
Was this letter copied on anyone from her union?
It was addressed to a shop steward.
Just to be clear, Ms. Provenzano's absence since October 2021, has that been authorized or unauthorized?
They were unauthorized.
And I just want to turn your attention now to Exhibit L. And what is this document?
This is a letter regarding a disciplinary hearing to Purina Provenzano.
And who sent this letter?
Letter was sent by myself,
And to whom was it sent?
Purina Provenzano, on September 15, 2022.
So I offer Exhibit L in evidence.
I object.
Pardon?
I object. I object.
You object to the letter?
Yes.
Did you receive it?
Yes.
Okay, what's the basis for your objection?
That it says misconduct. And then it says,
Again, these were the charges that were preferred against you. I just want to make sure that you received it.
okay, I received.
You know, you're going to ask him on cross, what was the misconduct? But, okay?
I got it.
And just as a way of housekeeping, Exhibits M and N are letters that I prepared and are under my signature to Ms. Provenzano and copied Mr. Bowman, hearing officer and others. And just regarding the scheduling of today's hearing, and I would introduce those into evidence.
I assume you have no objection. Okay. So, off the record, when I ask you that question, instead of shaking your head, for her sake, just say yes.
Yes.
remember the TV that you watch with our attorneys. Okay? What?
I have no further questions for Mr. Bennett.
Okay, you have some cross-examination?
Yes, I'd like to ask a question.
All right, let me go.
Before you do that.
All right, go ahead.
Mr. Bowman, are you familiar with the Constitution?
I object. Bowman is not here as an attorney. And actually, I object to having two parties, two individuals asking questions for Ms. Provenzano. She can either ask questions or her counsel can ask questions, but you can't have both.
Okay.
Where's a rule that says that?
That is typical ruling in any kind of court proceeding. I don't care who does it, and I'm gonna let you ask questions, but from now on, if you wanna ask all the questions, that's fine. If you want Ms. Provenzano to ask all the questions, that's fine. Make it one or the other.
Well, it's up to you.
Okay,
You
so-
want-
And if you want 10 minutes to talk to Mr. Williams outside, that's fine.
Yeah, let's just go out for 5 minutes. This will be quick,
Off the record.
off the record.
Yes. I'm not here to debate these letters, really, because like I said, I'm not here to defend myself against my right to not mask or test. It is not, it's not lawfully based, it's not scientifically based. So that is the essence of what this whole thing is about. We're here because I chose to not mask or test, which I have every right to do, which all these cases say as well. So all of this correspondence is a wash because it is not built on constitutional ground. Because like I said, your argument is I was insubordinate when I chose to not mask or test, or I was on unauthorized leave when I was ordered to come and didn't come. Well, you said I was told, it was made very clear to me that I was told specifically and in writing, if I come and I choose not to mask or test, I would be directed to leave. Knowing I will not mask and test, I was told that it would accelerate disciplinary action. So that is threatening me. So if I'm told, if you come and you do not mask and test, it will accelerate disciplinary action up to and including termination, why would I come? So you're trying to twist or spin what happened here. You're trying to take a scenario that I had every right to exercise my right to not mask and test and criminalize it or call it disciplinary. And that is not supported by the Constitution.
Okay. I'm gonna try to say this and correct me if I'm wrong. It sounds like, based on what you're saying, is you have no disagreement over the basic facts of this case. Your disagreement is solely on whether the college had the right to require you to mask and get vaccinated. Is that a simple way of putting your argument?
Not really. It's almost there, but not quite. Everything really, what's based on, to make everything simple, and God's law is simple. It's not confusing like the legal system. So anyway, the way it works is, the Constitution is the highest law of the land, and nothing supersedes the Constitution, not your Rule 75. And what you're doing under Rule 75 is in violation of her constitutional rights.
Sir.
And therefore, You can be held liable, and can be null and void because you're violating your constitutional rights.
Sir, stop with the constitutional rights for a second.
No, I'm not gonna stop. That's the highest law of the land.
Sir, would you listen to?
You can't, I'm not gonna let that be waived. That's the highest law of the land, Mr. Lobel.
Sir, would you listen to me for a
Go
second?
ahead.
I'm talking about the right, the detail that I have to look at in deciding this matter. Okay? Very simply, it sounds like you have no dispute about what the college did. Mr. Banks, in fact, really doesn't have to proceed with the facts, because the facts are not disputed. The question is simply whether the college had the right, the legal right, to say, Ms. Banks, you have to get vaccinated or you have to wear a mask.
Ms. Provenzano.
Or Ms. I apologize to both of you on that one. Ms. Provenzano, you either have to get a vaccination or you have to wear a mask. Pure and simple.
And get tested.
And whether it's right as a, and I'll even extend, whether it's a right as,
It's all under the same umbrella, really.
yeah, whether it's a right as the terms and conditions of employment or under the Constitution. I'm not even gonna argue, I'm not gonna get into the argument about that. Can you agree to that simple basis for this dispute?
Now, I will ask you a question before we answer that. Do you agree that Dutchess Community College is a corporation?
I have no idea. Dutchess Community College is the
Why don't you
employer.
ask your counsel? He'll know.
He's not my counsel.
I'm not counsel for the hearing officer.
Okay. You are
I
a
think-
corporation. Now, because you are a corporation, when you incorporated, whenever you did that, you have to follow the rules and the bylaws of the Secretary of the State where you incorporate. And that means you can't break the law.
Mr.
Now, you
Williams.
can make your rules
Mr.
as long as
Williams.
you don't break the law. You are breaking the law right now, which is Section 75, and violating her constitutional rights.
Mr. Williams.
That's what this all boils down to.
Mr. Williams.
You're acting ultra vires,
Mr. Williams.
outside the law.
When I say Mr. Williams, I am asking you to stop.
I'm
the
not
hear-
finished.
I'm
I'll
the
stop when I'm finished.
I'm the hearing officer in this matter, and I expect to have a little bit of respect given to the hearing officer.
And like you said to Pieta, I'm educating you too.
I am very simply saying, I'm trying to say as simply as I possibly can, what I have to rule on. And it sounds to me, and it looks like you provide a lot of material, or you've gathered a lot of material, as to whether or not basically, Dutchess County has the right to say, get vaccinated or
Get fired.
or get vaccinated, or wear a mask, or get fired. Pure and simple. And you're saying they don't, and they're saying you do. Did I say that right? Is that a fair way to explain what my
As long as it's in conformity with the Constitution.
what my decision has to be?
It has to be in conformity with the Constitution, and it is not. You could make up anything you want, but if it's not conformity with the Constitution, it's null and void. And therefore, you should give her her back pay and all her money and reinstate her, and this whole thing will be over. Because it's gonna go to federal court. This is a constitutional matter, if you're gonna consider continuing on violating the Constitution. That's what this is all about.
I understand his position where if Section 75, CSL Section 75, is not upholding the Constitution.
And I haven't read Section 75 in a few weeks. If I recall, Section 75 basically involves discipline for cause. Okay? Discipline for cause can be under a number of different reasons. I understand your concern about this particular case. It's a very involved case. I'm just simply asking if you agree to what I just said, is it necessary to proceed with all the, all the various evidence, or we just stipulate to the facts, and both of you submit briefs to me?
The cause right now is unconstitutional. That's the issue.
You
Your
didn't-
mask, your pre-testing is all unconstitutional. A mandate is not a law. A rule is not a law. What you're doing is unconstitutional.
Sir, sir, you didn't listen to what I said. You just didn't listen to what I said. I'm just simply saying, and I want Mr. Banks to also, it sounds to me that you have basically agreed. I'm not gonna say agreed, because you conceded that you refused to wear a mask and you refused to get vaccinated. You're basically saying, under the rights of their rules, under the, they did not have the right, as an employer, as a citizen,
That is correct.
to require you to wear a mask.
They don't have the right.
Okay, that's what I have to decide. That's all I'm saying. Is that, will you agree with that, and will they agree with that?
No,
What do
we
you
don't
base your
agree with
decision
that,
on?
and I'll tell you why,
What would
Peter.
you base your decision on?
Pardon?
You said I have to decide. What will you base your decision on?
On the evidence that you give me, on the decisions that both of you give me.
So you will go through all of this?
On-
I have sent it to you.
What?
I've sent it to you.
Case sites.
I've sent this document to me, this whole document to you in a spreadsheet.
Off the record.
Why off the record?
You sent me in a spreadsheet? When?
I sent you an email this morning.
Yeah, and just to be clear, I checked my email, I did not receive that, so I don't know if it's,
Really? Well, I
there's
can,
some issue, but sometimes with like, if it's a certain size, like.
I
maybe
can
they should-
resend it.
Okay, that's what,
Constitutional.
I would
Yes.
like a hard copy, okay?
Okay.
I would like a hard copy.
Do you want to put this?
Okay, go back on the record. I would like a hard copy of the decisions. I would also like, if you so desire, to write a brief as to pointing out to me certain decisions that you think are particularly relevant, because I know Mr. Banks will do the same thing. And I'll write a decision and we'll go from there.
If I could just address that, I think what's being proposed, to make sure I'm correct in this, the college has withdrawn specification number 1. So we have specifications 2, 3, 4, and 5 set forth in Exhibit B, which is the letter of July 19, 2022. If Ms. Provenzano stipulates that those specifications are factually correct, then we will proceed to essentially legal argument whether, assuming those are all, deeming those all factually correct, is there a legal reason why you should not be terminated from the college? And that would be addressed in the post-hearing briefing. What I would suggest and ask for, if that's how we're proceeding, and Ms. Provenzano is going to prepare essentially solely a legal defense based upon the legality of COVID-related requirements, any other legal argument she wants to present in her post-hearing briefing, instead of having what is generally a simultaneous briefing, I think it would be helpful if Ms. Provenzano, as the proponent of this legal defense, goes first, and then the college would get an opportunity to do a responsive briefing. And if for some reason she's of a mind and you're of a mind to receive it, there could be a reply brief. So it would be more of a legal motion that would be in court with the proponent of the legal ground going first, the other side responding, and then the possibility, if wanted, for a reply.
This all has to do with constitutional law, not your legal, whatever you do.
Well, okay, when I say
Under
legal,
constitutional law.
I include the Constitution. If you want to present a constitutional argument, I certainly, you can do that. I just want an opportunity to respond to it rather than doing, if we did simultaneous briefly, trying to anticipate what you're gonna argue.
Okay.
Yeah.
If we want to
Does
stipulate.
that sound reasonable to you?
But we're moving forward, and it's all under constitutional law. What he's trying to get at is legal. This is constitutional law, which is over the legal system, unless it coincides with it. So that's what I want to stipulate. His wording is leaning legal.
Mr. Williams, it sounds like this is relatively simple. It sounds like you are accepting the fact that about what you did.
I'm not denying.
No,
that-
you're not denying, there's no
that I will
denying.
not
You are just challenging the right
Yes,
under their,
under the Constitution.
under their rules as an employer and the Constitution of whether they have the right to do it.
No, you can't do that.
Well, not the employer, but the Constitution.
Constitution.
I'm gonna say,
Everything falls under that.
I'm gonna say it's both.
No, it isn't.
You have no,
Okay, we can let the paperwork speak.
okay, and here's the question. Here's the question I have for you. Did Mr. Banks' idea of you writing the brief, he responding, and if you so desire to respond to his brief, is that acceptable to you?
A lawful brief, not a legal brief. There's a difference between the two.
You both can write whatever you want. It is my right as the hearing officer, it is my obligation as a hearing officer to decide what is fit and proper and write my decision accordingly.
As long as it conforms with the Constitution,
Sir?
you're right.
Sir,
You can't do it without the Constitution.
at some point, please understand, I'm in charge of this hearing. If you want to continue to interrupt me and refer to the Constitution, I'm gonna get very annoyed.
So am I, if you're gonna keep rebutting me about it. That's what matters here, constitutional law. And I want that on the record, and I'm glad it is. Because when this goes, if it has to go to federal court under Title 18, Section 242, and you may wind up losing your house or your car because of this, you'll know why. All of you. Read that law. Okay, continue.
I am saying to you that I am asking you whether is the methodology proposed by Mr. Banks acceptable to you?
Under constitutional law.
Yes, it is.
Under
the
constitutional
It's
law.
true, of course, it's a given, under the constitutional law.
It is a factor of their rules and regulations, is a factor of whether they're consistent with the law of the land. End of conversation. Okay?
I'd like to say one more thing. I guess you'll have to tell me what a lawful brief is, because I included everything that needs to be said in here.
We're gonna go over that. I know what a lawful brief, we'll go over it. Pierre, it's
This-
okay.
This not only includes case sites, but it includes all of our correspondences.
Pierre, that's not to be discussed.
What?
We'll discuss
Okay,
that.
okay.
You're confusing. It's okay.
If I can just be heard on that, it might be helpful to discuss a page limit for the briefs. And I would object to putting in documents such as correspondence that should be presented as part of the record in today's hearing. Generally, a post-hearing brief are simply legal arguments. It's not an opportunity to include and insert new information into the hearing record. So if there are documents, correspondence, documents of a factual nature that you would like to include in the record, I would just ask that they be, presented today while we're still on the record. We're in this hearing before the hearing
Well,
officer.
that would be this.
No, we don't.
No. I understand the difference. It sounds like what you have in front of you are various decisions by other hearing officers, other courts, and all that.
Exactly.
Okay, if you wrote, something to Mr. Bowman, okay, that should not be included in there,
Why not?
because I want Mr. Banks to have an opportunity to cross-examine and discuss what she wanted, what she was intending to do with that document. So the only thing that would be given to me would be documents of a third party. If you want to talk about what was given, what you gave to the college, or the college gave to you, and you want to cross-examine Mr. Bowman about anything that he talked about in his direct examination, feel free to cross-examine him. Feel free to, we'll go back on the record. But the only thing that I want to see included is decisions of other people. Do you understand the distinction?
So you're saying we can't include our constitutional rights and that this is in violation of our constitutional rights? Is that what you're saying?
If you're doing legal briefing, you're citing sources of law. That could be a constitution, it could be a statute, it could be a written decision by a judge or another hearing officer. And I have no problem with that if you're developing a legal brief, you're making arguments of a legal nature, and you're citing recognized sources of law. What I'm trying to say is I don't know all the documents in front of you, but if there's some document that should be properly entered as an exhibit in the hearing because it provides factual information regarding your particular case, such as an email a supervisor may have written you about, your presence at work, the time to present that document is now while we're in a hearing and we're on the record. It should not be inserted in a post-hearing brief where I don't have an opportunity to question you or the proponent of the document, and I don't have an opportunity to raise objections, if any, to the hearing officer. That's all I'm saying. And I understand I'm coming from this with a little more experience as an attorney and a litigator and all of that. I'm trying to give you your opportunity to present the best legal arguments you want. I'm just saying that I don't want this to be an opportunity to do something that should be done within the hearing process as we develop the record.
We write up our brief. It's going to be what we feel is necessary to put in there. And constitutional law is what we're doing everything under, because right now what you're doing is, and have done in subordination, is in violation of constitutional law. And Title 18, Section 242. And you can stop this whole thing, and it could be done right now, if you just give her severance pay, reinstate her, and this whole thing can go away. Otherwise, it's gonna go further, and like I said, it could cost you deal in court. So, anyway, the ball's in your court there too, but we're going under the Constitution and under her rights, not her privileges, rights.
Ms. Provenzano, do you understand what Mr. Banks just said to you?
I understand what he's.
He probably said it a little bit clearer than I did. I just want to make sure.
I hear what he's saying.
Okay, and the time to talk about anything concerning the evidence in this case is right now. The time to talk about what you claim to have in your binder is you're going to send that to Mr. Banks and I. And if you want to write, a 10 or 15 page paper to highlight some of the things to me, that's fine. But I want to make sure that you're not going to present additional factual information about this case in a later brief. That's all I'm saying to you, and all. I just want you to understand that.
We have to confer on this, and we can't consent to that at this time.
Then we're going to proceed with the hearing, bluntly. Then we're going to proceed with the hearing.
Well, like I said, then you're gonna be in violation of constitutional law, and just be prepared for the consequences. We don't consent.
You don't consent to what?
To you proceeding with the hearing without, in violation of the Constitution. You want to ignore it, you're not adhering to it. Rule 75
okay.
is unconstitutional. What you're gonna do to her for insubordination, it's unconstitutional, you're violating her rights.
Ms. Provenzano, do you have any cross-examination to Mr. Bowman?
Okay, these are
You
my.
don't have to continue with this, because you're just capitulating to consent to what they're gonna do under their legal system. And now it's not under constitutional law. They're trying to trick you.
Ms. Provenzano, based on what you said, and maybe I misread your body language. If I did, I apologize. My understanding of what you were saying is the facts of this case are not in dispute. Whether or not they had the legal right to discharge you for failing to take a COVID test or failing to wear a mask is what this case is all about. If that is accurate, we can proceed very quickly. If I misread you in any way, shape, or form, we're going to proceed, and you're going to proceed with your cross-examination, Mr. Bowman, and the testimony of Ms. Rogers and whoever. It's up to you. I wasn't trying to bypass your rights. I was just trying to make it simple for you, because you kept referring to that document that you have. That's fine. I mean, I'm perfectly fine either way. If you have any hesitation about what I'm saying, please proceed with your testimony, Mr. Bowman.
What you are doing is against her lawful rights, not her legal rights. We're here in the constitutional law. And it's not about you legally, it's lawfully continuing. If you want to lawfully continue this hearing under the Constitution, which is the supreme highest law of the land, then we can do that. And then her rights are being addressed. She's here in her own
Mr.
proper
Williams,
person.
I really wish you went to law school.
I wish you did too. I wish you'd got constitutional law.
Very, very simply, Ms. Provenzano. Now that I'm listening to Mr. Williams, I'm sorry I had this conversation for the last 15 minutes. Why don't you proceed with your cross-examination, Mr. Bowman?
As long as it's under constitutional law. Remember, you're here with your rights. They're trying to do what they're doing under privileges, not rights, your constitutional rights. Because under the constitutional rights, this whole thing should go away, and they should reinstate you and give you all your back pay. Because they violated the Constitution. They violated your rights. And that's what it's all about. Sweet and simple. You can end this right here, right now, today. Just agree to that, and it's all over. We want this case to continue under her constitutional rights. If you agree to do it, we can go on. She's here in her own proper person,
So.
as a living flesh and blood woman. Now you have a choice.
Ms. Provenzano,
Is there a question?
I gave you a very simple way to curtail it, to cut this hearing short. I wasn't trying to shortcut any of your rights.
But
If
you did.
If you wish to continue with cross-examination, please feel free to do so. If you want to stipulate the way we talked about before, that's fine too.
As long as they do it with respect, under your constitutional rights, under the Constitution, then you can continue. But otherwise, they're not. You're doing it legally, and you're looked at as a fiction also. Remember, he's an officer of the court.
I have, as you can see, these are all correspondences.
These are all what?
That's me. Just do our briefs under the Constitution and your rights. That's all.
We'll do the brief.
What?
You will stipulate to the accuracy and admit to specifications 2 through 5, and then we'll do legal briefing?
No, not legal briefing, lawful briefing. Lawful briefing, under the
Briefing.
Constitution. It has to be lawful. You can't leave
Mr.
out.
Williams, you're making the distinction that I'm not actually
I'm trying
implying.
to educate Mr. Lobel. This is all about constitutional law and how she was deprived of her rights. And that's what it's all about, sweet and
Can
simple.
you tell me the date of that?
It is July 19th, 2022.
One second. Your question is what about this?
Do you stipulate that specifications 2 through 5 are accurate? Or that you do not oppose those specifications?
I oppose. I was not insubordinate.
We can end this now, let's just do our
And-
constitutional brief and we can all go. Simple.
Let her
I do not
answer.
agree with the word insubordinate. I was not insubordinate. I reported to work the very next day. Again, I was thrown off campus. It says here that on or about December 7, you were again directed to work. That's not true. You're referring to a letter that was dated on December 14th, not the 7th, and it did not direct me to return to work.
Okay, if that's the case, that you're challenging the accuracy of 2 through 5, please cross-examine Mr. Bowman.
Excuse me, before she starts, one of the observers who did put his name here would like to re-enter. Would you allow that?
I'm sorry,
One of the observers that was here who did put his name down would like to re-enter the room.
that's fine. I thought the way you were talking before that you did not dispute 2 through 5. If you-
No, I dispute number 2. I was never insubordinate. Can't use that word.
Then go ahead and ask the questions.
You see, as I read this, it's just the whole, it says on or about October 18, 2021, after you had exhausted your leave accruals, you were directed to return to work or face disciplinary actions. You were insubordinate when you did not report to work as directed. I reported to work. To say that I did not report as directed, this is where your mandates come in. On or about December 7, you were again directed to return to work or face possible disciplinary action. You were insubordinate when you did not report to work. Not true. I reported to work the very next day. Again, I was thrown out. And I made it very clear we had a meeting.
Oh, okay, then you have to ask a few
He
questions.
wasn't there. We had a meeting. He wasn't the,
Who was there, the former?
Ruth Spencer. Susan McGlynn was there. She's here. She's here and
Susan, who?
McGlynn. Yeah.
Okay, then I think you're gonna have to ask some questions.
I have, wait a minute. Do you need proof that I was here? On the 19th?
That's part of your presentation. So what you have to do is, you know what Mr. Bowman testified about. If you have no challenges to what he testified about, let's go to the next witness.
Well, these are my challenges. I'm expressing my challenges.
That's good. Ask him to do his president of the meeting.
Were you there October 19th?
No, it's not.
Okay.
So he's gonna call another witness.
Oh, Susan Marshall.
Do you have any questions of what Mr. Bowman, what Mr. Bowman testified about?
I simply don't agree with it. I don't agree with these stipulations. I don't have anything directed towards him.
Okay.
I don't agree with what this letter
Okay.
says.
Call your next witness.
So, thank you, Ms. Rowan. We call Dr. Susan Rogers.
No, that's not the one.
May I have a water?
What?
May I have a water, Mr. Lula?
Sure.
Thank you.
Excuse me, I'll be right back.
I'm a graduate of this college. Can I have a water?
Are we waiting for Susan Rogers?
Yes.
You're just getting Ms. Rogers. We'll help you down the steps though.
Oh, man, that was
You
rough.
know how nice I am.
The bag is heavy. He caught me on the last flight of stairs and helped me.
Oh.
One of the times.
Literally, that's what, literally 10 stairs.
Just at the 10 stairs. Believe me, that was helpful. I was done by then.
What?
Yeah.
Dr. Rogers, you sit next to me.
Ms. Rogers, would you raise your right hand? Or Dr. Rogers, do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing
Yes, I do.
but Proceed.
Good afternoon, Dr. Rogers. As you know, my name's Steve Banks. I'm an attorney representing Dutchess Community College in this proceeding. Where are you currently employed?
Dutchess Community College.
And what position do you hold?
Several. So my formal title is Chief of Staff and Vice President for Institutional Effectiveness. I'm also currently the Acting Vice President for Instruction and Learning.
Do you have any position within the Office of Academic Affairs?
So before February of this year, I was an Associate Dean of Academic Affairs.
Do you know Ms. Provenzano, the employee across from you?
Yes.
And has she held a position with the college?
Yes.
And what position did she hold?
Oh boy, was it office assistant or program assistant? I forgot. But she was an assistant providing administrative support in the Office of Academic Affairs. Part-time.
And generally, what were her duties as a program assistant in the Office of Academic Affairs?
So she supported all of the deans and the provost in the office. She worked very closely on processing the adjuncts, so new hires or reappointments. She helped with running the FLAC, the payments for the part-time instructors, and we would also give her additional projects. She would fill in anything we needed.
And just to be clear, adjuncts are adjunct instructors?
Yes.
Have you ever supervised Ms. Provenzano?
Not directly.
In the fall of 2021, were employees at Dutchess Community College subject to any COVID-related requirements?
Yes.
And what was the nature of those requirements?
So originally we were asked to mask. People who were not vaccinated were asked to test weekly. Everybody had the option to test weekly. Many of us did anyway. And that's basically, that was it.
Do these requirements apply to employees in the Office of Academic Affairs?
Yes.
Did they apply to Ms. Provenzano?
Yes.
And Dr. Rogers, in front of you, although I'm going to have to ask Mr. Bowman to share his copy of the exhibit binder.
You take my notes.
So Dr. Rogers, I'm going to direct your attention to the exhibit binder that's now in front of you. Specifically to Exhibit E.
Okay.
Do you recognize this document?
So next page or?
The document goes on, it's a two-page document.
Okay.
And it purports to be an email from Dr. Ellen Gambino dated Thursday, May 20th, 2021. You have to verbalize your answer
Yes.
for purposes of court
I see
reporter.
it.
What is this document?
This appears to be an announcement talking about the expectations for the return to campus for staff.
And at that time in May of 2021, what position did Dr. Gambino hold with the college?
She was the provost and vice president for academic affairs.
Did at some point she become president of the college?
Oh, was she the president at that time? I apologize. She may have been the acting president at that time.
Would it make sense as the acting president for her to send an email to all campus employees?
Yes.
And is this an email she sent to all campus employees?
Yes.
I'm going to offer Exhibit E into evidence.
Any objection?
She asked you about it legally.
Did you receive this document? E?
I received it.
Admitted into evidence.
Dr. Rogers, it states that this email was sent with high importance. Do you see that?
Yes.
And does this email set forth the COVID-19 requirements for Dutchess Community College at that time?
Yes, it does.
And if you look to item 6 of this email, does this refer to the requirements for employees who are not vaccinated?
Yes, it does.
And would you agree that those requirements, that such employees were to wear a mask correctly and maintain a 6-foot distance from others at all times?
Yes.
And item 7, does that discuss weekly testing?
Yes, it does.
And is that required of any person who has a physical presence on campus?
Yes.
Now, I want to direct your attention to another exhibit. If you go to Exhibit G in the same binder.
see it.
And this is a 2-page document. What is this document?
This appears to be an email from our interim director of HR with Spencer to Pieta, reminding Pieta of the obligations of the college due to COVID.
And the date of this email is July 6, 2021?
Correct.
And when you said Pieta, are you referring to Ms. Provenzano?
I am.
Are you copied on this email?
I am.
I'd offer Exhibit G as evidence.
Any objection?
I object to you calling it a requirement. A requirement is not a law.
The question is, did you receive this email? Did you receive the 2 emails on July 6th?
I received it.
Admitted into evidence.
Huh?
Therefore they're admitted into evidence.
On the second page of Exhibit G, there appears to be a memo from Ms. Spencer to Ms. Provenzano. It states in the second sentence, I think there's a typo there, but it should state, "It has been reported to me that you have not been wearing your mask properly on a consistent basis." Going back to the summer of 2021, based on your observations, was Ms. Provenzano in compliance with COVID-related requirements?
Ms. Provenzano would sometimes be wearing a mask that did not fully cover her mouth and or nose. It's also my understanding that she never did COVID testing on campus, but I could be mistaken about the frequency. I do know that it was very rare if ever. I don't think it ever happened.
Did anyone at the college ask her to comply with the COVID masking requirements?
Yes.
And who asked her?
Several of us in the office would ask her to wear her mask correctly. And she was also reminded to engage in the weekly testing.
And what was the nature of the response?
I think that if she was asked directly to adjust her mask, she would adjust her mask temporarily. I never had the conversation personally with her about the COVID testing on campus.
Were other employees in the Office of Academic Affairs compliant with COVID-related requirements?
Yes.
Would they undergo weekly testing?
Yes.
Would they wear masks correctly?
Yes.
Now, I want to direct your attention to Exhibit H, the following exhibit.
Yes.
This purports to be an email that you drafted to Ms. Provenzano. What is this document?
So first I'm seeing response, and then, yes, I'm seeing an October 4th email. This email summarizes the events that happened. On October 4th, Ms. Provenzano had asked that we recap the events and send them an email format, which we did, and you'll see that our interim director of HR is copied on there, as well as the executive assistant to academic affairs.
Okay, so just to break this down, this email has, this document has 2 emails. One is from you, dated October 4, 2021 at 9:31 a.m. Is that correct?
Yes, it is.
Is that email you wrote, Ms. Provenzano?
Yes, it is.
And the second email is sent from Ms. Provenzano to you and copied to others that same date at 9:51 a.m. Is that correct?
Yes, it is.
I would offer Exhibit H in evidence.
Any objection? Did you receive the emails?
I received emails.
Okay. Then
And Dr. Rogers, what was your purpose in writing the first email to Ms. Provenzano?
It was directly at Ms. Provenzano's request that we recap the conversation from the morning. And so I was just providing an overview of what we had discussed.
Did this conversation take place on October 4 of 2021?
Yes, it did.
When you drafted your email summarizing this conversation, did you accurately describe the topics under discussion?
Yes, I believe I did.
During that conversation, did Ms. Provenzano inform you that she would no longer be wearing a face mask?
Correct.
Did she inform you during that conversation that she expected she would be sent home?
I'm sorry, please repeat that?
During this conversation, did Ms. Provenzano inform you that she stated she expected she would be sent home?
I believe that she did say that.
Is that what you report in item number 3 of your email?
I know.
Yes, okay, very good. Yes.
It also refers to a vacant office, or rather, Ms. Provenzano working in a vacant office. What was the purpose in making that offer to her?
We were trying to accommodate Ms. Provenzano's requests to not wear a mask. I think we all recognized that she was very heartfelt in her belief around that. And so we thought that it would be an appropriate accommodation to ask her to work in an office that we had vacant, and to only wear the mask if she came out. This is relevant because her desk is in a public suite area, and so without a private office, she would have to wear a mask all the time. So we were trying to help her adjust.
And then in her responsive email from later that morning, did she state, as I was sitting there, I felt as though I was being isolated, punished, and treated as if I were some germ-infested leper?
She does state that.
And just remind us, on October 4, 2021, were employees in the Office of Academic Affairs generally required to wear masks?
Unvaccinated.
Yes. Now, let's go to Exhibit I. And what is this document?
This is an email from Interim Director of HR Ruth Spencer to Ms. Provenzano. And she is stating that although Pieta did report to her, she refused to comply with the protocols. Therefore, Ruth Spencer had asked Ms. Provenzano to leave, and she sent her additional information about that.
Are you copied on this email?
Yes, I am.
Is Andrew Calamari from the union copied on this email?
Yes.
I'd offer Exhibit I into evidence.
Ms. Provenzano, did you receive it?
Yes.
Admitted.
And do you know how Ms. Provenzano responded to this email from Ms. Spencer?
I believe she came to work the next day.
That'd be October 19th?
Yes, which happens to be my birthday.
Did she remain working on October 19th?
No.
What happened on October 19th of 2021?
We had a similar conversation. We met in this room. I was present, Ms. Spencer was present, Ms.
I'm sorry,
Provenzano.
I was present.
Ruth Spencer
Uh-huh.
was present, Ms. Provenzano was present, and Susan McGlynn was present. We tried again to have a conversation about what accommodations we might be able to make as the workplace to allow Ms. Provenzano to continue working in a manner that she felt comfortable on campus. We, I believe, offered again the private office. We also discussed the mandatory testing for unvaccinated folks on campus, and we said that, you know, if Ms. Provenzano was more comfortable with some alternative testing, she didn't want to engage in the testing that was offered here, that would be an acceptable alternative. I believe that conversation ended with Ms. Spencer telling Ms. Provenzano to take a few days to think about her options. And I think we were all hopeful at that point that we would be able to work something out.
Did Ms. Provenzano return to work after October 19th, 2021?
I don't think so, but I'm not sure.
What was the question?
She asked what was the question? Did Ms. Provenzano return to work after October 19th, 2021? And she answered, I don't think so, but I'm not sure.
Let's go to the next exhibit, Exhibit J. And this appears to be an email from Ruth Spencer dated October 15, 2021 to Ms. Provenzano. Do you see that?
I do see it.
Are you copied on this email?
I am.
Is Mr. Calamari from the union also copied on this email?
Yes.
I'd offer Exhibit J into evidence.
Ms. Provenzano, did you receive that email?
Yes, I did.
Entered into evidence.
And you read, Dr. Rogers, that in the email, Ms. Spencer writes to Ms. Provenzano, quote, your approved vacation will end as of today, Friday, October 15th. Do you see that?
I do.
And then she goes on to say, quote, you will no longer be on authorized leave, end quote. Do you see that?
Yes.
And she continues, failure to return to work and comply with the DCC protocols result in a written reprimand for insubordination and potentially job abandonment. Do you see that?
Yes, I do.
And then finally, let's get to Exhibit K.
Yes.
This purports to be another email from Ms. Spencer to Ms. Provenzano. This one is dated Saturday, October 23rd, 2021 at 6:37 a.m. Are you copied on this email?
Yes, I am.
Is Mr. Calamari from the union copied on this email?
Yes.
I'd offer Exhibit K into evidence.
Ms. Provenzano, did you receive
Yes,
this
I did.
email? What's wrong? Where is it? Ms. Provenzano, did you receive the
Yes, I
email?
did see that.
Okay. So entered. Okay.
This email refers to an accommodation. Do you know what that's referring to?
Yes, this refers to the conversation we had on October 19th.
About the use of an office.
Correct, and also looking for alternative testing.
Can you describe what you mean by alternative testing?
Ms. Provenzano did not feel comfortable using the COVID testing that was offered on campus, and so she had said that she was going to look into other kinds of COVID tests that she might be able to use on a weekly basis in order to meet the college's regulations at that time.
So just to be clear, Ms. Spencer writes in this email to Ms. Provenzano that when she goes out of the office that was being offered into any public space, inside any building, that she must wear a mask. Is that correct?
Yes.
And then Ms. Spencer also writes that Ms. Provenzano must comply with weekly testing. Is that correct?
Yes.
Do you know if Ms. Provenzano reported to work after October 23rd, 2021?
I don't recall.
Did she accept the offer of the vacant office to use?
No.
Presently, are there any COVID-related requirements for college employees? You have to speak up.
You can say yes, no, or I don't know.
No.
And how long have masking no longer been a requirement for college employees?
Quite some time.
Thank you. I have no further questions.
Any cross-examination?
Yes. Okay, so we're going back again, circles here, because everything you're saying about requirement and mandate is not constitutionally based, so it's null and void. And I'm not here to defend myself against my choices of not masking or testing. I also, she referred to Dr. Gambino's letter regarding following testing and for masking and testing. And in her letter, she had an attachment, and this was the attachment. And it talks about stipulations for, there's no testing mentioned for places where 250 for 250 people or less. Testing is only required for places.
I'm sorry, you have to speak up.
What is your question to me?
No, I'm questioning the validity of testing, because the email that was sent by Gambino had this as an attachment. And she said she was following the CDC guidelines. And these guidelines say nothing about testing for institutions that are 250 people or less. It only talks about masking.
Do you have a question for?
I object to the whole policy. I object to the whole policy of masking or testing.
Then your question is?
All right, my question is, you
What's the
said
justification?
is a requirement law?
When I used the word requirement, I was talking about college requirements as a place of employment for its employees.
Okay. There are some requirements that you simply cannot ask. You can ask for some that people don't, people don't.
Is that a question?
Okay, first let her answer the
Okay.
question, and then give me an opportunity to object.
So my question is a yes or no, actually. I just wanted to know if a requirement is law. Yes or no?
I object to that as argumentative. and
Try to rephrase it.
Okay, can you show me the code rule, law regulation that states that a requirement is law? And I have to abide by it for to be employed.
Object. Dr. Rogers is not an attorney, nor did she devise SUNY or the college's COVID-related
Well then,
requirements.
okay, well then why was she reprimanding me to mask and test?
You can ask that question.
By what authority did you have to reprimand me to mask and test?
So, I don't think that I reprimanded you. I think I asked you to follow the policies that the college had in place. And I did that as both a colleague in the office, and as the senior associate dean in the office at that moment. Both Dr. Gambino and Maria Boato were out.
Did your asking me, am I not complying, constitute that I would be asked to leave?
If you're asking if it led to that event, it led to that event.
Another thing I'd like to address is...
As did your choice not to mask or take any of the accommodations.
Yes, the accommodations, Are accommodations typically used for handicapped people?
Objection is argumentative.
Try to rephrase, I'm not sure what you're getting at.
Why did you feel I needed accommodations?
Because you were a respected colleague and we were trying to honor your wishes and keep you on staff.
You were offering me accommodations because I refused to mask, so that I would not be in the public around other people.
So that you would not be violating the college policy.
Okay.
For the record, what was the justification for the college policy? Was it handed down from above?
Yes, I didn't make this policy.
Who made the policy of masking requirements? Do you remember?
I don't, but we had a campus safety committee that was very active at that time, and I would guess that it came from, as a recommendation from to the president.
Through the university system?
I don't know if that's true or not.
Okay.
I would actually like to know that. I would like to know who actually had the authority to impose masking and testing on his employees contingent upon their employment.
I would object to that. I don't think we need to go into that for purposes of this hearing.
I object to that objection.
Well, this is going to be something that's going to be done in your brief.
Mm-hmm.
And you're gonna argue that the college had no justification to make this policy, and they're gonna argue that you did. They did.
I also would like to, on October 19th, the day that I was directed to leave, I wrote an email summarizing the events of the day, and I have here, see, I didn't know I had to make copies for everybody. I have it in the email I sent you guys. I arrived at work at 9 a.m.
Who was the email sent to?
It was sent to Ruth Spencer, Andrew Calamari, Mary Ramaglia, Susan Rogers, Susan McGlynn.
Oh, okay, so why don't you give her that email and see if she remembers it.
Yes, I remember this email.
Okay.
Can I take a look?
It's from October 18th, what time?
You can find that you can find that on your email, on your phone?
Maybe.
That shows the difference between somebody that age and somebody my age.
What was the other name after Calamari Ramagli? To spell it.
It states here Ramaglia.
Okay.
It's Mary Ramaglia. If Ms. Provenzano is offering this into evidence, I have no objection, and I believe we can probably get a clean copy to include with the hearing record.
Okay.
Why don't we, why don't we either see if we can get a clean copy or make copies of that real quick? Is it easy to make copies here? Okay. Why don't you put that to the side right now, and we'll make copies of it, unless Susan Rogers can find it, and then I'll be really impressed.
I did find it, but I'm just looking at other communications.
Okay.
Is it easier to have a copy of that made?
Well, in all honesty, all of these emails are emails that I had sent to the college and asked questions and sent letters.
Okay, go back on the record. All those,
Okay.
go on.
For the record, I have a pile of emails here of questions that I had asked various administratives, Susan Rogers, Jordan, and the CSEA, and nothing these letters were never, they were ignored.
They were never responded to? Did was Miss Rogers on all of them, or don't you know?
No, she wasn't on all of them. It's just a pile I have of letters that were never answered.
Okay, would you give the copy to Mr. Banks for a second?
This,
Yeah. Off the record, you know what I'm trying to get at, Steve. What I'm gonna see is, can we just admit them without all sorts of testimony back and forth about whether they were, somebody got them?
Give me a second to review.
Absolutely. Well, you're taking a second. I'm gonna take 2 minutes. You're smart.
This one, I think, yeah, I think that was, we did that earlier.
You still have Provenzano Boulevard, isn't it? Because I'm gonna send you a copy of this, just to make sure I send it to the right place.
And so this
Do
is the
you
only
want an
one we don't
email
have.
too?
What time did you send that email? This morning?
oh, this morning,
Roughly,
just before I left.
10 o'clock?
Give me your email.
Okay, so before we go on the record and make this official,
Just make sure you
Okay.
put it down for me, so I can send it.
I didn't get either, by the way.
Okay, I'll resend it.
No, yeah. Okay.
so,
No, we're off.
yeah, we're off. I just want
Okay,
to
no
go
problem. Thank you
over,
so much.
and we'll put this on record later. So the number of communications here,
Excuse me, did you say off the record?
well,
No, do you want to be, I thought you wanted to be off for a second.
I just want to be off for a second. Yeah.
Oh, okay.
Yeah, and then we can go on. I
Yeah,
just
okay.
wanted to clarify what I'm proposing here. So this October 26, 2021, I have no objection to that. Again, we probably just need a better copy. July 27, 2022, which was the demand for a hearing, I have no objection to that, and I actually have 2 clean copies already that can be used.
Wait, I'm sorry, which one you don't have an objection to? Which one, July 27th?
July 27, I have no objection to that. In fact, I can give you clean copies for vision. October 19, 2021, we're okay with that. And then you have some emails for extensions of the hearing. I don't have an objection to that. Because I certainly put in my own correspondence regarding the adjournments. I would object to this email concerning Anne Marie Rambo, who's not the employee at issue in this proceeding.
Is it, it's an email. Can I see it?
I don't have an objection to your correspondence, Mr. Roman, dated June 2nd, 2022. The only other objection I have is this letter dated May 18th, 2022, mainly because I can't confirm that that was received by the college. So,
What about letters, C7 and C8? Oh, you're, no, sorry, C6 and C7.
see that here.
Um,
Let's see, C9, C12.
I thought I saw you. No, it was Kathy Kundar,
Oh,
who's a lawyer in New York City. What?
a reporter?
No, a lawyer.
Oh.
I went to law school with her.
Oh.
And I saw her name, and I said, oh my God, you're gonna be. Give me a pen.
Chapman. So I put that in a Congo, I'm like,
Everything you say is right if she argues as a corporate action. If she argues the Constitution, constitutional law matters. She can
Yeah.
argue this, but it's a crap show because this is a private hearing.
oh, frog and toad. Sounds familiar.
Honorable Ben. My cousin.
Oh, right.
See, the main thing
I
is
remember
they
the story
fired
about
her
him.
for
I
insubordination.
remember he saw the sign. He said he's kind of German, but that guy was really brilliant. And he saw the symbol of the sign and he made it more
That's the thing,
complicated.
everything you're
I
saying
remember that
is
story.
mandate or rules or policy. These are all laws, and if they don't conform to the Constitution, they're null and void. That's my argument.
Yeah, I remember that story.
And he's sticking. Yeah, you're right. What the attorney will do is he'll pick the one that he feels he can win on and beat that to death. They fight one, and they get you to
Actually,
argue
if you
one,
have that
that's the
with Dr.
argument. I've
Sheila,
been to court.
can we print that? Please? Because I was looking for one.
Did you mark all these?
Yeah, they are, they
They're-
appear to be
they're-
marked.
Yes, but like I said, since I put it all in the email, I thought.
for a fact that
Okay.
So,
a lot of the American people have, that we're going to change anything?
Sorry
Because you got
Would you please turn that off?
Yeah, I am. Sorry about that.
so, yeah, just, when we go on the record, I will not object, oh, let me put this, but the only documents I'm objecting to are C10 and C9.
Okay, so you're accepting C6 and C7?
Yes.
Oh, okay, are you okay with that?
Yes. Is C11 there?
Yes.
Are you, can you accept that as well?
Yes.
So you're accepting C12, right? C6, C7, C8, C11.
C11, let's see, C15, 9. I do not see C12. Oh, I do, you have it, yeah, that's fine.
Okay.
Okay.
Why will you not accept C13 and C14?
I think they were.
I did accept
Oh, you
that. The
did,
ones
okay.
I'm objecting to were C10, May 18th letter,
May I
because
see it?
Mr. Bowman says he doesn't recognize that. So I don't know if that was in fact sent or received by the college, and I object to C9, because that's, at least those 2 pages, because they concern another employee.
What other? C9? Oh, my sister.
Yeah.
Okay. So this is C10. Okay. Give me 1 moment, please. This is enough to make you mad.
Who are the twins? Oh, true.
Him and her.
No, the redhead and the guy next door.
I remember they didn't look alike. You couldn't tell.
It was a.
I love it.
That's cute.
Thanksgiving. Okay.
Will you accept C1?
You showed today. I don't know if that was.
There. This is definitely a test.
What?
These emails. I think I lost one.
I don't see C1 in this one.
Okay.
Are you okay with this, with what he said? You know, then we'll just admit it and not have fights, you know, not have.
No, yeah. I'm just trying to make sure that I've included the emails that I think are important to be.
Pardon?
I'm just including the emails that I think are important.
Okay.
I have another copy of this. If I find a copy of this with the certified mail return receipt number, can I submit it?
If you have proof that was delivered to the college, subject to
yeah.
return
Yeah.
tag,
Yeah.
that's fine, yeah.
Okay.
At the moment, I just don't know if it was.
Are you, sure you did that?
I have another one home with the certified mail receipt number.
Oh, okay. Here's, okay. Put that down for a second.
Yeah.
Do you have any further questions, Ms. Dr. Rogers?
The email.
Are we back on the record?
Oh, okay, I'm sorry. We're back on the record.
The email that you had asked me for originally, that was dated, I think, October 18 or 19.
Okay.
Is it here? Do you have it?
There's an October 23rd, Exhibit K. There's an October 18th.
It was one that okay, this is actually, it's Exhibit K.
Which exhibit are you talking about?
Exhibit K.
Okay.
Which documents the events that took place on October 19th, which was the last day that I was here. So you had mentioned our Dr. Shiva study that I had sent you guys.
When you were talking about emails?
Yeah.
Yes.
So, I don't remember, and I have to find it, but you have it, so it's great. I sent that maybe just a few days or the week prior. It was a comprehensive 3-year systematic study on masking. And I sent it to all of them. And I had said to Ruth Spencer, I asked if they watched it, and I'm sure they didn't, but Dr. Shiva in this mass study concluded, among many other things, that masking, because it changes the oral pH of your mouth, adversely affects your brain, your heart, and potentially your lungs. It's known now that mask wearing increases your risk for pneumonia.
I'm sorry, increases.
Your risk for ammonia. So I had told them that my mother has Alzheimer's, and the study said that wearing a mask increases your risk for Alzheimer's. And my mother's late-stage Alzheimer's, so there's a predisposition for that in my family, and I mentioned that to her. And she said to me, and I quote, "Well, that's something you have to think about." And I just,
So you're reporting that it Spencer said that?
yes,
Did Dr. Rogers hear this conversation?
yes, she did.
Okay.
She was there then.
I don't know, I don't recall Ruth's response, but I remember you expressing concerns about all students.
I mean, we can call Susan McGlynn because she was there too.
I don't recall the words Ruth Spencer spoke in that conversation. I recall the conversation though.
Can I call Susan McGlynn?
Well, I'm gonna leave that to the hearing officer. I just want to point out that Dr. Rogers is still on the stand, and
Yeah.
if there are no questions for
Are there any more
No,
questions?
I have nothing more to say to her.
Okay. Okay, well, then you're
I
done,
didn't
Ms.
mean it
Rogers.
that way.
You're dismissed. You're dismissed.
You may stay, or you may go.
I'll say.
Okay. Do you have any further questions? Any further witnesses?
The college has no further witnesses.
Okay.
I would like to call a witness.
You would like to call who?
I would like to call a witness.
Okay.
She works here in the Department of Academic Affairs.
Is she here now?
Yes.
Okay. Who is it?
Her name is Mary Lou.
Mary Lou?
Mary Lou.
Okay. Can you get her?
Me?
Does she know you're calling her?
She doesn't. I mean, if she objects,
Mark, do you want to ask?
Because I think the hearing officer will agree with me on this, because the witness is not subpoenaed, she has no obligation to testify in this hearing. If she wants to, and is willing to participate, she may.
Exactly right. Exactly right.
So I think my point is there a neutral person that can go and speak to her about whether or not she would like to do this?
Okay. Off the record now. I don't care. Steve is absolutely right there. We can't force her to testify.
of course, I can't. force
I'm gonna ask you, who's the best person to ask her?
Oh, here?
Yeah. Will she say yes to you? Will
I'm
she?
gonna say Anthony.
Well,
Is that right?
I don't think that feels
I mean, he's
neutral.
neutral.
I don't think that
I'd rather.
What about Matt
How
Del
about,
Who?
Can we send Matt?
Why don't we send one for both parties?
That's good too. Mary Lou, I would just like to ask her a question.
So please make sure she understands that this
That's
is
all.
optional.
She doesn't have
and
to.
Yeah.
Okay.
She, Mary Lou, she sits at the desk to the right in instruction and learning.
Okay, that's fine.
Can he ask as well?
I'd rather, let's just her ask. I don't even know where he works, so I'm not gonna say yes. I have no idea who he is.
She just wanted him to witness her
I
asking.
have no idea who he is.
We have no idea who she is either. We don't know her.
I can tell she's a guard at this place. Okay,
And I can tell he's a-
let me do this. Get back on the record. In off-the-record conversations, there was discussions about emails that the respondent would like to have entered into evidence. I have a pile of them that both sides seem to agree on. These would be admitted into evidence. I'm not gonna go through them and identify them one by one. What I'm gonna do is ask the college to make copies of them, staple them, and I will put them into evidence. Is that easy enough?
that's fine with me.
Okay, and I know they're marked up. You'll have to trust me that I will ignore the markups. Okay? Off the record now. Who's the easiest person? Mark, can you have somebody just copy all this? And just make 2 copies, give one to each of these guys and one to me. We will staple them, and the minute you say they're all okay, they'll be entered into evidence. How's that sound? Making me stretch.
Those are only copies.
I have it also online.
I want you to have that copy so that Steve and I can refer to it.
Okay.
Okay?
Are we off the record or on?
We're off the record now.
I have something I'd like to on the record.
Oh, okay. First time when I was coming here, well,
Oh, okay.
do you have any witnesses?
Can I call Susan McGlynn?
Can you call who?
Susan McGlynn.
Who was that, the person that you were?
It's the second person that works here. She was here, she was present the day of our meeting, the last day.
Okay. Is she here now?
No, I don't know, is she in the same office?
Yes.
She is, yeah.
Off the record again. The information supplied by the employer, or by the, I'm sorry, by the respondent, and it is all admitted into evidence without testimony. Do you have any other witnesses?
No, I do have something I want to say.
I'm gonna allow you to talk a little bit as if you're your own witness. Okay? And with the understanding that Mr. Banks will have an opportunity to respond. So, do you want to talk right now, or do you need a couple minutes to?
No, I can talk.
Okay.
I would like to ask if it is okay that email with the Dr. Shiva study be included.
I can share it for consideration.
It was another email that I put out trying to show people the other side of non-human testing and vaccination. That was never responded to.
So I understand this was a study that you shared with the college back in October or fall?
No, it was with the department, far back then. The few people who I was corresponding with.
And when did you share that study?
It was the week prior to my meeting on the 19th, because I cited it on the 19th. I asked if they watched it.
It's an email or?
It was an email with a reference to a study.
I'm sorry, what's it, with a what study?
A reference to a study by
Reference
Dr.
to-
Shiva.
Okay, this was a medical study.
A medical study. It's just another email that was never responded to.
Because this is part of the dialogue you had with the college at that time, I will not object to that being included as
Thank you.
as an exhibit. We just need to get a copy of that.
Okay, great.
Do you have a copy?
I couldn't find it, but when she said Dr. Shiva, I knew that's what she was talking about.
Can you find it and get a copy?
Mm-hmm.
She's so damn impressive.
She's good.
Okay, now back on the record.
So what I want to say on the record is, we had an email from October 22nd, email from Ruth Spencer to me, Andrew, Mari, Mary, Daphne, Susan McGlynn, Susan Rogers, and Maria Laura. And between the date of that email on October 22nd, the next time we heard back from them was December 14th. And that was 53 days later. And then after the email of December 14th, and we had written as well, we responded. We didn't hear back again until March 18th, which is 94 days. And then from March 18th, once we responded, we didn't hear back again until May 9th, which is 22 days. And then from May 9th, a letter from Mark Bowman to me, CCA shop, Stuart Peter Jordan. The letter from May 9th, which we responded to, we didn't hear back until July 19th, 71 days. And then finally, in a letter that was responded to from Mark Bowman, July 19th, we didn't hear back until September 15th, which was 27 days. And we were just, my question is, why did this take so long? It's quite possible that on some of these letters, we did put time bars for responses. I'm pretty sure that on these letters where we responded and requested a response in return, there were time bars. Where's my section 72? Do you have it? Section 72. One more thing I would like to mention about section 75 is that it says Henry, I'd like you to listen to this to make sure I get it right. It says, in the event the hearing officer finds that a reasonable period of time was not afforded, then any and all statements obtained from said questioning, as well as any evidence or information obtained as a result of said questioning, shall be excluded. The part I'm questioning here says, provided, however, that this subdivision shall not modify or replace any written collective agreement between a public employer and employee organization negotiated pursuant to Article 14. To me, that means that you cannot change the contract of the contract that I accepted for being hired here. And when there's nothing in my job description that talks about waiving my rights for masking and testing. And I think this says, provided, however, that this subdivision shall not modify or replace any written collective agreement between a public employer and employee. So that's a violation of your own rule. I believe when you change someone's contract to work, you're supposed to stipulate it in plain language and make sure they're informed. I was never received or informed about any such provision to my job description. Another thing, in section 75, it says suspension. And please note that this is right when it does say suspension. It does not talk about unauthorized leave. This is a suspension.
Okay, I'm not trying to, again, you're talking about things that you're gonna rate in your brief.
Okay, I just wanted to be noted for the record.
Yeah. And those are fine. I wanna know, are there any facts that you wanna bring forth right now as to what happened between you and the college?
Well, you know, I was served with a section 75 hearing. That's something that happened,
Okay,
so.
but that's a legitimate fact, and you're now arguing why this shouldn't, section 75 shouldn't apply. I'm not disagreeing, I'm not agreeing or disagreeing. I'm saying, are there any, and I'm going back 2 hours now, are there any dispute as to the facts of what happened in this case that you want to bring up right now?
As pertaining to what exactly?
Pertaining to anything. You're gonna make an argument in your brief as to why the college was wrong or wasn't allowed to do what they did. That's fine, I expect that. And I ultimately will make a ruling on that. But right now, I'm trying to make sure that the record is secure as to the facts of this case. And it sounds like by your body language.
Yes.
Correct. from what you can say, the facts of this case are not in dispute.
Yes. So one more stipulation in section 75, says, suspension pending a termination of charges, penalties. Pending the hearing and determination of charges of incompetency or misconduct, the officer or employee against whom such charges have been preferred may be suspended without pay for a period not exceeding 30 days. So we all know it's been 14 months now. It says if such officer or employee is found guilty of the charges, the penalty or punishment may consist of a reprimand, but it says suspension without pay for a period not exceeding 2 months. So there's a time factor in here that has also been violated.
Okay. Anything else?
Just for the record, want to state one thing, it's short and sweet. Mandate is not a law, requirement is not a law, protocol is not a law, regulation is not a law, policy is not a law. And Ms. Rogers mentioned those words a lot of times when she gave her talk. So I just want that for the record. They're not laws.
Okay.
Under the Constitution. Okay, go ahead.
I've been exceedingly patient and I'm losing it.
I've been patient too, so we're equal.
But you're not the hearing officer and I am, and please remember that.
We're friends. Go ahead, continue.
Here's how we're gonna proceed, if this is okay with you. You are gonna write a brief. You are gonna include in your brief all the decisions that you have mentioned today. Okay? You will submit it to me and to Mr. Banks. Mr. Banks will have a period of time to respond, and we'll talk about that in a second. If you want to respond to his brief, that's also okay.
I would just like to say, in Henry's honor, for the record, a lot of what Henry says is true. It says here, and for the record, a mandatory, required, mandated, requested, ordered, ordinance, decree, or compulsory are not laws. So I'm just stating that for the record. And one more thing I wanted to state, which I said before, when you talked about a lawful brief, and I asked about submitting studies, you said that their scientist isn't there to qualify it or to verify its validity. And I said, well, that didn't apply. That scientist or that doctor was not around to qualify and substantiate the validity of masking testing or vaccination. So it is a two-way street. So this was imposed upon me. I have the right now to present an argument that you can take or leave, but I will present it in my brief. My lawful brief.
Okay. How much time do you think you need to write your brief?
Well,
Off the record.
30 days reasonable?
I've never done anything like that before.
Pardon?
And that
I don't really-
you do have the holidays coming.
No, that's why I asked the question. Do you want 30, if you say 30 days, that's December 29th.
No, go for 60.
The Christmas thing.
The 60.
Yeah.
Even I can accept that.
Okay.
Do you want,
Can we do 60 days?
I think that's too long.
Can we do 50 days?
Why don't we do you want to do 45?
Okay.
What date does that make it then?
Yeah.
Maybe they probably want this too.
Well, how long will you need?
Well, usually I say 2 weeks. I'm also in the midst of another expedited hearing.
I think that'd be January 16th, would be 45 days.
Okay.
Is that Martin Luther
Let me
King
look
Day?
at my calendar.
Can we get some?
No, it's the 16th, that's Martin Luther King Day, so maybe the 17th.
Why don't we make it briefs due, this will give you a little bit more time. Briefs due January 20th,
Very good.
okay? Your reply brief,
We get 30 days, that would be adequate.
reply brief due, I'm gonna say February 17th,
Fine.
okay, February 17th. And,
A response to his reply.
and reply to his, I'm gonna make that quicker. March 3. That's 2 weeks.
Okay, so January 20 and March 3rd.
Okay, I'm gonna say this, you know, God willing, everything with your mom is gonna be okay. But I heard, if God forbid something happens, let us know, okay? We are, I'm not sure about him, but I'm relative to him.
And
I couldn't resist that.
is there a page limit? Or just-
I'm gonna say reasonable page, I see what she has in terms of the,
You know, here's the thing, with case studies, you can go right to the order and the judge page in the back.
okay,
So
okay.
that's a lot of what that's.
Let's go back on the record, real quick. In off-the-record discussions, it was agreed that the respondent's brief would be due January 20th. The reply brief would be due, from the employer would be due February 17th. If there's a further reply by the respondent, it will be due March 3rd. Is there anything else that we have to go through today?
I would like to say one more thing. One more thing, sorry. I just would like to be noted for the record, the reason why I asked Mary Lou, and I know she's not here to verify, that I was subjected to discrimination and harassment. When I was not wearing my mask, I was treated like a vector of disease. I would walk down the hall and people would be afraid of me and try to duck me or go into their offices because I was passing by them. That is why I did not accept accommodations to be put into this office. I felt it was blatant discrimination and completely unwarranted. We have to account for symptoms when someone is sick. We don't go to the doctor and the doctor says, "What's wrong?" and you say, "Well, I'm breathing great, I have no aches and pains, I'm fully functioning, I'm working." So what are your symptoms? My symptoms are nothing. So that's where real science comes into play, and that's clinical science. Relying on a PCR diagnostic is not, to put a whole pandemic, the whole world, based upon PCR results is pseudoscience. And because you have nothing to compare the PCR against that is gold standard. You can't compare PCR against PCR. You have to compare it with a gold standard, which is cell cultures and things like that, which is not done here, which is not, has nothing to do with you or me, but this is where we're at.
Oh, okay. I heard what you just said. And to me, that's more testimony than a summation. So I am going to give Mr. Banks,
I'm simply noting it.
if he wants to, an opportunity to cross-examine that testimony, because it's a funny kind of testimony. It's testimony that you're not asking questions of yourself. Mr. Banks, do you want to ask any questions about what Ms. Provenzano just said?
I think I would, thank you.
when you were working in the Office for Academic Affairs before October 19th of 2021, were other employees in that office wearing masks?
Some were, the mask policy was changing every other week. 1 week, always for the vaccinated, you always had the masking test, which is blatant discrimination. People who were vaccinated had options at times to mask or test if they chose.
So you did see employees who were vaccinated not wearing masks?
Yeah.
And you saw employees, or let me ask you.
But you see, I didn't really keep track because I'm not afraid of people who are or are not vaccinated.
And just before the record, you yourself are not vaccinated.
That's none of your business.
Well, let me ask it this way. In October of 2021, were you vaccinated?
That's none of your business. I've not asked anyone if they've been vaccinated.
Okay.
It's none of my business.
Did you purport, let me withdraw that and ask you this way. Did you inform your employer in the fall of 2021 that you were vaccinated?
I would inform them that I had rights and that no one has the right to try to coerce me to take it or try or encourage me or these emails that we were getting often were calling it an opportunity. We're encouraged to do it, and it was a climate where the unvaccinated people were fearful, and I know that.
And you would agree that there was reason, based upon your response, for your employer to conclude that you were not vaccinated?
Why do you want to get to the fact, to the question of whether I am or am not vaccinated?
Because you just testified that there was essentially different policies for those who were vaccinated and those who were unvaccinated.
Sure. I never revealed my vaccination status.
Okay. And I think in your testimony a moment ago, you believe that there's some failings of the COVID testing.
The science speaks for itself.
Are
The
you
creator says that.
Are you yourself a scientist?
I am not.
Do you have any degrees based in the science?
I have a plant-based certification from Cornell University.
I'm sorry.
Say it again.
I have a plant-based certification from Cornell University. I've participated in anti-aging studies. I've worked in weight loss clinics. So this is an area of passion.
Okay, let me ask it this way. Do you hold a bachelor's degree?
No.
Do you have a master's degree?
No.
Do you have a PhD?
No, I do not.
Do you have a medical degree?
I don't want a medical degree. That's what dictates the PCR. That's what medical.
And
I'm just giving you my personal experience,
And you were in New York last year, presumably. You reside in New York, correct?
Yeah.
And when you went to the supermarket, did you observe patrons of the supermarket wearing masks?
Where are you going with this? There are patrons that are still wearing masks in the supermarket.
But you would agree in early 2021, masking was required in supermarkets.
Again, we said required is not law.
Okay. You may
Requirements
dispute.
are not law.
Okay, you may
Well, you can let the cases speak for themselves.
I can look
That's
at those.
exactly what they're about.
I can look at those, but would you agree just commonly, a lot of people in New York State were wearing masks in public in the early part of 2021?
A lot of people were, a lot of people weren't. So what does that mean? What does that conclude?
And I just want to be clear, you've reviewed scientific studies regarding the efficacy of masking requirements?
Of course.
How many?
Well, my sister and I, we blood, sweat, and tears to put this together, and there's so much out there now that the hardest part about this was trying to eliminate studies.
Did you eliminate
The
studies?
the latest study is on 6,000 people for Mount I mean, because I thought there would come a point where you would say, that's enough, you can't show us anymore, otherwise we could have stacks.
Were these studies published in peer-reviewed journals?
Yes, they are, of course.
And which journals did you review?
I don't have it off the top of my head, you'll see it in my brief,
And where did you review these journals?
online, from immunologists, virologists, people who have been in the business for over 40 years, not just anybody. Double-blind, placebo, gold standard, controlled.
But you yourself do not have a bachelor's degree
No,
in
I do
sciences?
not, I do not. That does not mean that I'm not capable of reading something and understanding it. And that doesn't matter, really. By the same token, neither do you. So we should not be pushing anything.
And you agree that the leadership in the Office of Academic Affairs offered you a vacant office to work from without having to wear a mask inside that office?
Had they offered me that office prior to COVID, I wouldn't have minded, I would have accepted. But the only reason why I was given that or told to go there was because people thought that I was some sort of threat to them, and that is not true.
I have no further questions. And I should point out for the record, I don't recall if Ms. Provenzano was placed under oath.
I think you're right. Would you do me a favor? Was all your testimony true and accurate in your mind?
Yes.
Okay, I'm gonna consider that you were under oath. How's that sound?
Best of your knowledge and
To the
belief.
best of my knowledge and belief, right?
Okay. You swear or affirm that
Of
I
course
can
I
sign. Okay. Do you have anything further, Ms. Provenzano? I think we're done, everybody.
Nothing further from the college, thank you.
Okay.
I want to thank you for allowing them to stay.
Thank you all. This is one of my more unusual hearings.